But, one pending matter, my lord.
Huh?
One
Yeah.
pending matter, NGO, my lord. NGO, my lord, one NGO is my lord, running, my lord, some business. my lord.
Mike.
On NGO is my lord, some social works are going on there on, my lord. Here, my lord, land has been already, my lord, selected, and state government has already, my lord, about to allot their land, my lord. But DLC district level, my lord, committee has not, my lord, considered. That's why, my lord, one petition is, my lord, pending here.
When you pending
Pending, my lord, pending.
next week?
Yes.
Lordship, may I pray for a listing of a motion matter day after tomorrow, your lordship?
After
Yes,
tomorrow?
Day after tomorrow, some urgencies there in view of, we have challenged the proceeding, your lordship, of cooperative society election, your lordship.
Who was the bench file?
Okay.
Yeah, please. Well, I pay for listing of a matter for motion, matter, tender matter, matter, on matter, Friday, matter. So, one matter pending matter, matter, for orders, matter, on Monday.
Next week.
Right, Monday, matter. Hello, let's.
Please, your lordship. I beg to mention in WBC lordship regarding settlement of market lordship. Lordship for day after tomorrow lordship.
Not day
For
after tomorrow, Friday.
Friday, then Monday lordship, if lordship confidence. Lordship.
May please, your lordship. Lordship, I like to mention for listing for lordship. Three matters for listing, lordship.
Subject matter,
Regarding settlement of Mahal lordship.
Mahal,
Mahal lordship.
motion or pending?
Pending lordship.
Pending is next week. দিব।
Monday lordship. Next week. Monday.
Yeah, please, your lordship. Lordship, I beg to mention for listing, my lord. PMO is a house, my lord.
কি মানে house সমর্থন হয় নাকি? Perhaps bench file. Other rules. Maybe bench file. Maybe bench file.
Hello.
Supplementary list for withdrawal, item number 7.
Wait, please, it's a lordship, man.
Yes.
The petitioner does not want to press this petition, my lord.
Okay, Mr.
HP Gwala, my lord.
HP Gola, learned counsel for the petition has submitted that he has received instruction not to press the petition on behalf of the petitioner. So in view of the above submission made by Mr. So this petition is dismissed as not pressed. Same.
Same, my lord.
8, 9.
Liberty may be granted.
What liberty?
My lord, they have, my lord, already instructed to withdraw this petition, my lord. Or consider the issuance of an IMFL license, my lord. In the event of, my lord, not consideration, my lord.
Has submitted that the petitioner wants to withdraw the petition with the liberty to approach again in the event of
Non-consideration.
arising in the event of any subsequent cause of action.
Obliged.
Absolutely, as prayed. Liberty as prayed.
For motion, item number 10.
Please, your lordship. Your lordship, my senior is on legs. The matter may kindly pass over for time being.
Yes.
Item number 11.
Actually, I think, my lord, your lordship knows more than me, ma'am. Your lordship may know more than me, my lord. Actually, the lordship reads it, my lord. My lord, he's a registered,
May please.
my lord, all enterprise.
May pass over the matter for timely lordship. Lanet, you can senior counsel is appearing lordship in this matter. He is online in court number 6 lordship.
Sometime, time being.
You can have. Yes, sir.
Top of the list, item number 1.
May please, lordship. Here, lordship, the petition number 2 has expired. So I called his son, he come to my chamber, thereafter I prepared the substitution petition. Thereafter I am not getting any response from him. So I will be allowed to, I will serve a retirement notice. I would like to serve a retirement notice to the legal
Okay.
heirs of the petitioner number 2.
Mr. SP Roy, learned counsel for the petitioner, has submitted that as the petition number 2 expired on 6/6/2023, he tried to contact the legal representatives of the petition number 2 to continue with the repetition. First of, as he has not been able to get the necessary instructions, he intends to file a retirement notice. He intends to serve a retirement notice for withdrawing his name from the litigation. First of, he has sought for
30, minimum 30 days, because dim service will be
6 weeks.
accepted only after 30 days.
6 weeks.
Lordship.
Yes, Mr. Roy. He has sought for listing of, he has paid for listing of the
Otherwise,
petition
it's abated.
after 6 weeks.
Since it is abated, lordship may dispose on that, but if they come later, Lord, that is, I don't know.
How it is abated? Oh, proprietorship concern.
Contract, carrying goods to Arunachal Lordship.
No, petition number 1 is a proprietorship concern.
Yes, Lordship.
So one and the same.
One of the same, but the proprietorship firm will not be represented by any person after death of petitioner number 2.
I don't know about that. One and the same normally. Legally, one and the same. He has paid for listing of the petition after 6 weeks. Mr. P. K. Roy, standing counsel, FCI, appearing for,
FCI.
6 to 8.
Mr. Who is Mr. A. Chandran, learned additional senior government advocate, Arunachal Pradesh, for the respondent number 1 and 2.
1 to 5, Lordship.
1 to 5.
5.
And Mr. P. K. Roy, learned senior counsel, for the respondent number 6 to 8 are present. Mr. Roy, senior counsel, preparing for the respondent FCI authorities have submitted that in view of the date of the sole proprietor of, in view of the date of the petition number 2, who is the sole proprietor of the petition number 1 proprietorship concern, the petition has abated. So stop. As sought for list by Mr. Roy, learned counsel for the petitioner, is the case on after puja vacation.
Obliged.
8 November, 8/11.
8/11.
Item number 2.
This is an application against an award, my lord.
Award,
Yes, my lord. Award passed by industrial tribunal, my lord.
industrial tribunal. Where is that?
My lord, before that, my lord, I will take your lordship in brief to the facts. Because my lord, the petitioner, he was appointed as a temporary worker on 1/10/85. Thereafter, he was given permanent appointment, my lord. And he was the general secretary of the workers union, my lord. And in the capacity of the general secretary, my lord, he espouses the cause of the workmen, my lord. And regarding, my lord, the payment of bonus, a conciliation was going on, my lord. And during pendency of the conciliation proceeding, my lord, the petitioner was transferred to faraway place, that is Tamil Nadu, in Konnur of Tamil Nadu district, my lord. That is on 27/11/2004. And my lord, petitioner, my lord, prays for my lord, consideration of that order, my lord. But ultimately on 5/1/2005, my lord, he was released from service, my lord. And against that, my lord, industrial dispute was raised, and I will take a lordship to the award, my lord, now. Because in this case, great injustice has been done to him, my lord. And
Who is for respondent?
No, no, I am representing, madam.
As for number one,
1 and 2, madam.
How
One,
can-
sorry, one, sorry.
if you represent one and two
No,
conflict
no,
of
one,
interest.
one, madam, sorry.
Annexure 9,
Page 32.
page 32. Award dated 28/10/2012. The case is referred by the government of Assam by letter number 20 for adjudication under section 10 of the Industrial Dispute Act 1947. And the following issues were framed by the government of Assam, which goes as follows. Whether the management of Tilwar Private Limited, Makum Road, Tinsukia, Assam is justified in stoppage of work of Sri Bachababu Singh with effect from 5/1/2005. If not, whether he is entitled to reinstatement with full back wages with effect from 5/1/2005 or any other relief in lieu thereof. As per reference, a case was registered before the tribunal. By reference case number so and so, this is issued to the contesting parties. The workman is also represented by the General Secretary, Steelwork Workers Union, and the management side also is represented by the Learned Council. They have filed their WS to contest the case before the Industrial Tribunal Dibrugarh. It is pleaded by both the sides that the government of Assam referred the case taking decision by awarding in the case that there is an industrial dispute in between the contesting parties on the basis of issue referred in the case. It is found that in pleading of the parties that it is also pleaded that Bachababu Singh has been transferred to Kannur in the state of Tamil Nadu in their another unit by the management. However, the workman Bachababu Singh declined to follow the transfer order of the management Steelwork Private Limited, and he refused to go to Tamil Nadu as it was not the normal transfer. It is also pleaded that workman Bachababu Singh had been attending duties at Tinsukia in the Steelwork Private Limited. However, the management side passed order for stopping him to go to his duty from 5/1/2005 for declining to go to Tamil Nadu on transfer of Bacha Singh. It is also pleaded that Bacha Singh joined in the factory in question in the year 1985. Thereafter, the management promoted him and confirmed him in service for his diligent act for dutiful to service and sincerity. However, management always shows hostile attitude to him beforehand also, and he has been dismissed many times. However, at the direction of ALC, he has got service again, and he joined in the factory again. However, during the time of this transfer, there was a negotiation for bonus in the office of ALC. During this period, the management transferred him to the state of Tamil Nadu, and it is required to join by him forthwith from 15/10/2004. However, on refusal to join by the workmen at Tamil Nadu, the management extended time to join Bachababu to their sister concern, and railway ticket was purchased to undertake journey by him. But Bachababu Singh did not obey their order, and it is also pleaded that he is a permanent workman. However, there is no reason to transfer without permission of ALC. It is pleaded by the workman's side. Therefore, it is pleaded to pass an award for declaring stoppage of his duty by passing an order of the reinstatement with full back wages, and to declare the act of management is an illegal act in the eye of law. And there was no exigency in the transfer of to Tamil Nadu. At the same time, the management side also filed WS, and it is pleaded that government of Assam referred the case without any valid return of malice towards the employee or on lacking sincerity on the part of the management. On the transfer order of the management, that there is no exigency in the transfer order of the workman Bacha Singh. However, the management side always shows hostile attitude towards him before his termination also. It is not the fact that he was dismissed from service, and due to the direction of the Honorable High Court, he was reinstated. It is not a fact. He has been requesting again and again to join his service in the Kannur branch, and it is also pleaded that it is justified to take steps on Bachababu on 5/1/05 to maintain internal discipline of the company. So there is no question of reinstatement of Bachababu Singh with full back wages. It is pleaded. It is pleaded that Bacha Singh was the employee of Steelwork Private Limited. He has been transferred on 27/11/2004 to Kannur branch. Due to exigency of service, he had to join in his service with effect from 15/12/2004. As Bachababu was an expert workman, and he is at the Tamil Nadu company, a unit of the Tinsukia factory. However, the workman by an order dated 6/12/04 has requested to cancel the order of transfer of the management. On 7/12/04, again asked the workman to go to his new assignment for joining, and also stated that there will be no further extension of time to join in his new assignment on 1/1/05. after that and had a last opportunity given to go to his assignments, though there was repeated declining to join by Bacha Babu. However, Bacha Babu requested to accept a letter dated 7/12/04 of the management. The management issued the letter to Bacha Singh on 5/11/05 by extending time for his joining. However, Bacha Babu refused to cooperate with them, and it is also directed to go to his new assignment by purchasing railway ticket to go to Coimbatore, and traveling facility was also provided to the workman. And even then, he did not comply with the transfer order of Bacha Singh. It is therefore decided by the management to stop his work to maintain internal discipline of the company. It is a fact that the workman Bacha Singh did not follow the order of the management as transfer is a condition of service. It is settled law on that point. The workman side has not silence. Therefore, Bacha Singh committed misconduct, which led to stoppage of his attending service at the Tinsukia factory of the management. There is no question for adopting unfair labor practice or stoppage of work of Bacha Singh in attending duty by him. Therefore, pray to dismiss the reference case by passing an award in favor of the management that Bacha Singh is not entitled to any relief at par reference case, and it also pleaded that an award may be given as everything is done by the management lawfully, and it is pleaded that the duty of the concerned workman is to follow the order. And apart from that, the management said nothing to carry out any order of management by Bacha Singh as transfer is not a termination of service. In this regard, workman witness number 1, Bacha Singh produced evidence, and he has also examined in cross-examination by the other side in his evidence. He failed to establish that management did not transfer him on exigency and that he has been transferred for another reason, having any ulterior motive to harass him by the management side. Management witness number 1, Baldev Singh, also produced their evidence in addition to the other evidence. The evidence of Bacha Singh is recorded, who has also proved various documents. Exhibit 1 is the appointment letter. Exhibit 2 is the certificate of management in the year 1992. Exhibit 7 is the conciliation proceeding for bonus for the AC accounting year 2000.
Whose document is this? Exhibit 1 and 2, etc. Workman or management?
Management.
This
Exhibit
English
three-
is not clear, language is not clear.
Yes, madam.
Who has reduced this exhibit 1, 2, etc.? Because the paragraph starts with that management witness number 1, Baldev Singh also produced their evidence
Yes.
in addition to oral evidence,
Oral
comma, the evidence of Bacha Singh is recorded, who has proved the various document.
And this is, it seems, Mali, it is the exhibit 1 is by Bacha Singh, madam.
Bacha. Okay. Yes.
And all these records are before lordship, madam.
Hmm?
LC record is before your lordship, madam. It has come.
Now, have you examined it?
Yes. madam. Exhibit 1 is the appointment letter dated to 11/85. Exhibit 2 is the certificate of management in the year 1991. Exhibit 3 is the conciliation proceeding for bonus. Exhibit 4 is award dated 24/6/2004 passed by the tribunal. Exhibit 5 is a notice of conciliation for bonus. Exhibit 6 letter of management dated 27/04 notifying the transfer of workmen. Exhibit 7 is the conciliation proceeding. Exhibit 8 is the minute of conciliation. Exhibit 9 is a letter of the assistant labor commissioner to the management. Exhibit 10 is the letter of the workman union. Exhibit 11 is a letter by the assistant labor commissioner to the management. Exhibit 12 is a letter by ALC. Exhibit 13 is a certified copy of the judgment dated demand. And my lord, exhibit 13 is important, my lord, because on this point, already there is a decision by this single judge of your lordship, and it was affirmed by the writ appeal, my lord. On that point, whether the workman is a protected workman or not, my lord. If a protected workman, it cannot be transferred, my lord, without permission of the conciliation officer during pendency of the conciliation proceeding. That is the moot question your lordship has to decide, my lord. And by exhibit your lordship's order, my lord. Single bench judgment in 1455 of 2005 and the writ appeal judgment, my lord. That is that both the judgments are before lordship, my lord.
Okay. Exhibit 13 and 14.
Yes, my lord.
Okay, let us proceed, then we'll see.
In this regard, the management side also proved the following documents. Exhibit 1, transfer letter of Bacha Singh. Exhibit B, letter of Bacha Singh. Exhibit C, letter of management on extension of time. Exhibit D, letter of management. Exhibit E, letter number 214 and 215 with refuse envelope. Exhibit F, letter dated 2010-12-2000 for extension of time on joining of Bacha Singh. Exhibit D, letter of management dated 28-12-2004 with refuse envelope. Exhibit is power cutting of Purbansal Basari dated 7105. Exhibit I, Xerox copy of cancelled railway ticket. Exhibit J, letter of Kannur branch informing non-arrival of Bacha Singh. Exhibit K, standing order of the company. From the evidence of WW1 Bacha Babu Singh, it is found that he joined the company in the year 1985. On 1105, he found a letter by which, by transfer order, he has been transferred to Tamil Nadu. His service has been terminated by the management for some ground before his transfer. However, the management had always shows hostile attitude towards him before his transfer. Also, he has been disciplined from his service frequently on many occasions. He was demanding for getting his dues and dues for the other workmen, as he is the leader of the union of the workmen during the time of transfer, as it is the duty to look after the welfare of his co-workers as union leader. However, during the time of his transfer, the workmen approached to the ALC demanding more dues from the management in question. During this period, the management has transferred him to state of Tamil Nadu to join with effect from 15/12/04 in their another factory. The management issued another letter dated 27/11/04, and the management did stop his duty when he refused to go to other company of the system concern of Tamil Nadu branch, as he felt so it was an harassment episode of the company towards him for demanding more benefit from the company for all works of the company. However, the management transferred him so that no dues wages it is necessary to be paid to him and to entire workmen to avoid the payment to deprive the workman the monetary benefit to the workman, and that this was the reason of his sudden transfer to Tamil Nadu. Afterwards, the management by vindictive its stoppage is attending duty at Tinsukia. In this regard, he has proved various exhibits 1 to 14 to show that now he has been transferred from Tinsukia factory, by which the management take charge against him by transfer without following any procedure of law. For protected worker, though he was a protected worker and he was transferred ignoring the procedure lawfully. In his cross-examination, he said that company transferred him to their another factory, but it was not according to law. And the management make a hasty decision by which he has been victimized for raising voice for a co-worker. And it is thus the tortioning it is to him as a leader of the union. However, from the evidence WW1 Bacha Singh, it is found that he has been transferred by management. However, he refused to go to Tamil Nadu further, and it is established on that point. There is no doubt on industrial dispute in between the parties in contest of this case. From the evidence of MW1 Baldev Singh, it is found that Bacha Babu Singh is an employee of Steelworks Private Limited. On 27/11/04, the management has transferred him to their sister concern, Kannur branch. However, Bacha Singh refused to cooperate with them, and he started to go to factory at Tinsukia, and therefore the management did stoppage his work on 5/1/05. And it is found that he did not obey their order. As a result of also the workmen of Bacha committed misconduct, defying the lawful order of the management of transfer. From Exhibit 8, it is found that he has been transferred as per letter dated 27/11/04 to Kannur. However, Bacha Babu refused to accept the letter. Exhibit A, Exhibit C, Exhibit C on extending time for joining for carrying out the order of the company. Exhibit 1 is the appointment letter of Bacha Singh. It is found that he joined the factory in 1985. Exhibit 2 is the certificate of management on his employment. Exhibit 3, minutes of conciliation proceeding. Exhibit 4 is the reference case, which has been awarded in favor of Bacha Singh by tribunal. Exhibit 5 is notice of conciliation bonus. Exhibit 6 is the transfer order of the workman. Exhibit 7, the conciliation proceeding. Exhibit 8, another conciliation proceeding. Exhibit 19, the letter of LC to the management to transfer workmen to Kannur. Exhibit 10, letter of the workman. Exhibit 11, letter to the management, Steelworks Company by the ALC. Exhibit 12, another letter. Exhibit 13 is the certified copy of the judgment of WPC 1455/2005 by the Honorable High Court. And Exhibit 14, another order of the Honorable Guwahati High Court passed in bill number 287 of 2005. At the same time, from the exhibited management document, it is found that Batsa Singh has been appointed by them with effect from 1/10/85. However, transfer order is issued by the management on 27/11/04. Batsa Singh did not follow their transfer order. However, in spite of getting the extension order to join in the new assignment, such as it refuses to go on transfer, in this regard, the management side also approved various documents to show that Batsa Singh refused to join the new assignment. MW Baldev Singh said that they transferred Batsa Singh to Kurnool branch. However, Batsa Singh refused to join his new assignment. As per his transfer order, he has been transferred to other factory, and not for that, for demanding more bonus from the factory during the year of his transfer, and did so in accidents of the situation of the factory. MW1 also said that the workman has been transferred for joining new assignment. Then by transfer is the condition of service. Exhibit A also the transfer order. Dated 27/11/04, Exhibit B is the letter of Batsa Singh. Exhibit 7 and 8 are the letter of the Assistant Labor Commissioner on bonus issue of conciliation. However, it is found that this said that Exhibit 1 is a letter written to the management by the ALC for transfer of workman. It is asked to the management whether he is the protected workman or not. It is suggested by MW1 Baldev Singh, as per company law and company bylaw, he can transfer the workman during the period of taking evidence. He reveals by submitting the provision of 64 of Assam Industrial Law on protected workman to explain the code of the authority. It is submitted that for employee, that management has to declare the protected workman in every year, and the union shall communicate to the employer before 30th September in each year, to whom management shall consider who will be the protected workman. And it is duty of the union every year to do that, filing the list of that. There is no list of the workmen recognized as protected workmen for declaration. So, however, it is submitted in this case that they did not declare the workman in question as a protected workman. However, it is submitted that without declaration of protected workman, he or she will not be protected workman. It is not required to follow any rule laid down by the Industrial Dispute Act. And there is no reason of taking permission to the Labor Department for transfer and even for termination of such employee. At the same time, no letter was proved from the union to show that they are protected workmen. As a result of that, there is no reason to hold that Batsa Singh is as a protected workman with declaration of management side. From the previous document of the management side and from the evidence of MW1 Baldev Singh, who said that they have issued transfer order by transferring Batsa Singh. However, he refused to join in the new assignment. As a result of that, I have found that there was a conflict in between the contesting parties and industrial dispute arises, and the Batsa Singh referred this dispute to the Assistant Labor Commissioner, that he has been stopped his work in attending office and the factory by the management. As a result of that, I have found that from various documents filed by the management and by workman side, Exhibit A to Exhibit 1 and Exhibit 1 to Exhibit 14, I have also found that. Also file Exhibit A to Exhibit 9. I have found that Batsa Singh has been transferred to Tamil Nadu in the Eastern Concern Factory for joining new assignment. I have felt that workman Batsa Singh committed misconduct by not following the order of the management, by defying order of management as the transfer is a condition of service. It is settled law. Management has the authority to transfer of the employee in their factory to another place, and so transfer of the workman is a prerogative of the management. It is also found from Exhibit 1 that the workman has been working in the factory from the year 1985. He has been transferred to in their sister concern branch of Kurnool at the time of the dispute for bonus. However, his transfer order has been extended with time to join in his new assignment as Batsa Singh is an expert workman. Therefore, he has been transferred by the management. It is found that before this, there is no transfer order issued by the management since 1985. However, the workman Batsa Babu Singh refused to follow the transfer order. This, as a result of that, he committed gross misconduct and he could not have gone to Kurnool after settling the dispute of bonus. After settling the dispute of bonus, if he had a good intention to carry out the order of company, but in the letter as addressed to the management, he never prayed to management to give him time to settle the dispute of the bonus and to move to Kurnool to a new assignment. But I do not find any good tendency of Batsa Singh on his part, and he virtually started to challenging the authority of the management. It is found in the evidence of Batsa Singh, and the same thing it is found in the evidence of the management equally. And it is found it goes without rebuttal, it is found and the evidence of both sides, and it is at the concluding stage of this case, it is found that Batsa Singh did not follow the order of the management fully, the transfer order. As a result of that, I do not find management has done anything wrong by unfair means for unfair labor practice for transferring Batsa Singh to other places, and there is no instance of his transfer since 1985. And this was the first transfer in his life. In this regard, I have found that whether the management stops his duty or he has been terminated, it depends on the circumstances of the employee, how he behaves in a given situation like this. It is found that the management has given appropriate opportunity to join him in service in extending the time to the workman in question. However, the workman Batsa Singh refuses to carry out the said order of transfer to Kannur in Tamil Nadu. So I feel that this indicates a gross misconduct from the part of the Batsa Singh he has committed, and he has done various illegal acts by informing the matter to different authorities to cancel his transfer order by using the force and threat. And it is also found that he's used their whole union members for that purpose. And this is a purpose finding, my lord. And this is observation is without any basis, my lord.
Which one?
This one, my lord. So I feel that this indicates a gross misconduct from the part of Batsa Singh he has committed, and he has done
Page, internal page.
internet page 12. Last portion, my lord. He says, my lord, learned court says Batsa Singh has committed and has done various illegal acts by informing matter to different authorities to cancel his transfer order by using force and threat, and it is without any basis, my lord. And it is
They
also,
have not shown any document.
no, nothing, my lord.
Uh,
He has also
Before the labor commissioner, it is okay. It is a competent authority.
yes, my Therefore, madam, I have found, I feel that there is no reason to consider that stoppage of work of purchasing is unjustified with effect from 5105. And there is also no justification for reinstating him with full back wages unless he have carried out the order of management for the sake of internal discipline of the management. If some employees persistently refuse to join duty, they may be dismissed from service. If such dismissal is made without holding inquiry, an industrial dispute is raised and referred to the tribunal, it is open to the employer to justify their action before the tribunal by adducing evidence. And in this regard, I can place reliance on the following decision. My decision number so and so 1972-277. And in that case, the Honorable Supreme Court observed as follows. The learned advocate for the respondent, however, urges that even when the strike is illegal, in order to justify the dismissal or order terminating the service of workmen on the ground of misconduct, the management must prove that they are guilty of overt such as intimidation, incitement, and violence. It is observed by the Honorable Apex Court that they do not think that in every case the proof of overt is necessary prerequisite. In this case, there is no persistent and obdurate refusal by the workman to join duty, notwithstanding the fact the management has done everything possible to persuade them and give them opportunity to come back to the work. But they have, without any sufficient reason, refused as per Honorable Apex Court, constitutes misconduct and justify the termination of service. In the light of this case, I also found that the workman.
All are repeated. All things are repeated.
Yes, everything is repeated, my lord, and this is without any basis, the discussion has been made, my lord. Moot question before your lordship is whether the workman concerned is a protected workman or not, my lord, under section 33, my lord. That your lordship will examine.
Industrial. Let me have a look at the exhibits first.
I will take your lordship to exhibit 13 and 14, my lord.
On,
That is important.
on.
Thirteen page 80, 14 page 88.
1 minute. Earlier, there was termination of Bachababu Singh.
Termination, my
There was a
lord.
reference.
And there was a reference and.
An award is of
for a
24/6/2004.
Yes, my lord. That is the award of reinstatement and that reference is no connection with this case, my lord.
1 minute. Termination of so is not justified.
In the capacity of a
Yes, sir.
general secretary, my lord, he is espousing the causes, my lord. That is his offense, my lord. That's good. Evidence.
Yes, exhibit 13.
And 14, my lord.
Yes. Let us
13
see.
is page 80. And relevant observation is at paragraph 10.
Division bench, while dismissing this writ appeal, appears that paragraph 10 was quoted,
Yes.
and thereafter it was observed that paragraph 4 has clarified that a writ petition is being dismissed as not maintainable, being premature without expressing any opinion on the merits. And that in deciding a matter, he is clarifying that all issues pertaining to merit has to be gone into by the authority concerned, irrespective of the observations made. So making thereby this paragraph 10 might have become redundant.
Yes.
Observation made in paragraph 10.
Observation is there.
Now you have to individually show.
Yes. But
That is gone perhaps
yes.
because of division bench.
Then I will take your lordship to section 33C, my lord.
(33C).
33C.
33 capital C or 33?
33,
1C.
33, 33A,
33A. 33.
33C, my lord. Section 33, my lord. Condition of service, etc. remain unchanged under certain circumstances during pendency of proceeding.
Right. 33 only.
33, my lord.
Not C.
C, my lord. During pendency of any conciliation proceeding before a conciliation officer or a board or any proceeding before labor court or tribunal or national tribunal in respect of an industrial dispute, no employer shall, in regard to any matter connected with a dispute, alter to the prejudice of the workman concerned in such dispute, the condition of service applicable to them immediately before commencement of such proceedings. For any misconduct with the dispute, discharge of punishment, whether by dismissal, workman conscience and dispute, and
No, during the pendency of so and so before conciliation officer, no employer. In regard to any matter connected with the dispute. Now,
No, no,
dispute is bonus.
Yes. No. I should check.
Dispute is, I think, bonus.
I'm pointing out, my lord. That's-
Bonus for the accounting year 2003, 2004.
No, my lord, here it says, my lord. I'm taking your lordship, my lord.
No, question will be during the conciliation proceeding, whether an order of transfer is permissible or not. In the manner involved here is permissible or not.
And
Right,
that-
so far, it started, it appears from the record. I can say that exhibit this order 19/10/2004 of the Assistant Labor Commissioner. He says, whereas an industrial dispute exists or is apprehended between the management of Steelworth and the workmen represented by the General Secretary Steelworth over the issue. Issue is bonus for the accounting year 2003 and 4. Now, section 20.
Section
20. A conciliation proceeding shall be deemed to have commenced on the date on which a notice of strike lockout under section is received by the conciliation, or on the date of subsection 2. A conciliation proceeding shall be deemed to have concluded
when a settlement is arrived at.
or where no settlement is arrived at. So it started from 19/10/2004. So, and it continued, it appears from the record that it continued even
On the date of. the statute.
on 28 December.
Yes. Is good.
So during the conciliation proceeding, this order of transfer has been made,
Yes,
right?
yes.
Now, he is a general secretary
Yes,
of the union.
yes,
His signature appears.
yes,
Now, this protection under section 33,
yes.
under which subsection?
That is. That is true, my lord.
Because only thing is justified or not justified.
Yes,
Only dispute.
section 33, subsection 3, my lord. Notwithstanding anything contained in subsection 2, no employer shall, during the pendency of any such proceeding, in respect of an industrial dispute, take any action against any protected worker concerned in such dispute by altering to the service of such protected workman the condition of service applicable to him immediately before the commencement of such proceeding, or by discharging or punishing, whether by dismissal or otherwise in such. So I covered by.
33A. Now, the question is whether he is a protected.
Yes, my lord.
Let us see explanation. Explanation is, for the purpose of this subsection, comma, a protected workman in relation to an establishment means a workman who, being a member of the executive or other office bearer
Yes, bearer.
of a registered trade union connected with the establishment is recognized as such in accordance with the rules made in this period.
In this period.
What are the rules?
On that, my lord.
I think some reference was made about
Yes, my lord. I will say-
rules in the repetition.
Yes,
Rule 4 of the Assam Industrial Dispute Rule 64. and subsection 4. He has to be recognized.
Yes, my lord. And on that, my lord, I will take it to the paragraph 10 of Singhu. on-
10,
Yes.
but division bench has diluted that position,
But my lord, division bench says
right?
it's not exactly
It
diluted.
appears from a reading of the judgment
Yes,
quoted in paragraph 10 of the judgment, because they were not challenging the dismissal of the writ petition.
yes,
They were challenging the observation made by the single judge in paragraph 10.
paragraph 10.
And division bench in paragraph 4
Yes,
says, we find that the learned single judge has clarified that the writ petition is being dismissed as not maintainable, being premature, without expressing any opinion on the merits of the case. And that in deciding the matter, he is clarifying that all issues pertaining to merit has to be gone into by the authority concerned, irrespective of the observation made.
observation made, my lord.
So that observation goes.
Yes.
Paragraph 10 observation goes.
Yes.
Now you have to stand on your own feet as a protected workman.
As a
If you are protected workman and conciliation proceeding was on, at that time, your conditions of service has been altered. I think then it will be a case of unjustified
Yes.
act.
Yes.
But if you are not a protected workman, then it cannot be termed as an act of an unjustified act, perhaps.
Yes,
Only issue is that. Now conciliation proceeding was on, there is no doubt.
yes,
Conciliation officer was in season of the proceedings. No doubt. And in between that, this transfer order has come. Now, under what provisions of section 33,
whether he is a.
your
recognized-
case comes,
Yes.
that is to be
Yes,
submitted.
after some
Right.
time. Yes.
Okay, just I will come back.
Yes.
Who is the appropriate government here?
State of Assam.
State of. What was raised before the government from the workman side? Transfer, okay. For your appointment letter.
Transfer of him to Tamil Nadu, my lord.
Ah,
And as because, my lord,
I am the general secretary,
yes, my lord,
recognized,
And my
affiliated
yes.
in the various science when containing people. Dismissed. After working. In his letter 6/12/2012, he did not mention anything about protected workmen. Anyway, That Assistant Labor Commissioner mentioned it.
Yes. And Assistant Labor Commissioner report reflects that he is a protected workman.
Or where is that letter?
It is annexure 5, my lord. Annexure 5,
The letter dated?
5 January
Okay,
2005, my lord.
he's protected.
Protected. It reflects, my lord. It has
Right.
been alleged that
Now. This Assam rules. Assam rule says. When a dispute arises between an employer and any registered trade union in any matter connected to the recognition of protected workmen under this rule, the dispute shall be referred to the Labor Commissioner, whose decision shall be final. Just because he is a general secretary, he cannot be a protected
Again, my lord,
workman.
if your lordship permits me, I will take your lordship to section 33, my lord.
33, yes.
Subsection 3.
Hmm.
Notwithstanding anything contained in subsection 2, no employer shall, during pendency of any such proceeding in respect of an industrial dispute, take any action against any protected workman concerned in such dispute. A, by altering to the duties of such protected workman, the condition of service applicable to him immediately before the commencement of such proceeding. Or B, by discharging or punishing, whether by dismissal or otherwise, such protected workman. Say with the express permission in writing of the authority before which the proceeding is pending. Explanation. For the purpose of this section, a protected workman in relation to an establishment means a workman who, being a member of the executive or other office bearer of a registered trade union connected with the establishment, is recognized as such in accordance with rule made in this behalf. Then, my lord,
Now the explanation is important.
yes, my lord, thereafter I will take you also to clause
Is
4.
recognized as such in accordance with rules made in this behalf.
Thereafter, I will take a lawsuit to subsequent, my lord. 4. In every establishment, the number of workmen to be recognized as protected workmen for the purpose of subsection 3 shall be 1% of the total number of workmen employed therein, subject to a minimum number of 5 protected workmen and a maximum number of 100 protected workmen, and for the opposite purpose, the appropriate government may make rule providing for the distribution of such protected workmen among various trade unions, if any, connected with the establishment, and a manner in which the workmen may be chosen and recognized as protected workmen. So my suggestion on this, my lord, will be, my lord, 5 workmen has to be declared as protected workmen. And
So
being general secretary.
whether by virtue of his holding the office of General Secretary of the recognized trade union,
Yes,
whether he becomes the protected workman without any further order from the management.
my lord, on that, my lord.
That rule does not say so.
Yes, my lord.
Rule
But it says, my
64.
lord, 5
I am
workmen.
looking into rule 64.
Yes,
Appropriate government is state government.
yes, my
They have framed their rules, set of rules,
lord. Yes.
and rule says 64 protected workmen. Now that has to be, there has to be a letter in writing from the trade union side
On
to the management.
yes,
These are the
protected workmen.
protected workmen. So please recognize them. Then management has to recognize them in writing. Right. Now, whether this rule further says that General Secretary automatically becomes a protected workman. That maximum number, all those are there.
5, my lord. And when maximum
But-
number is there,
And on the other hand, paragraph 10,
it implies, my lord, the general secretary. will reduce,
imply
my
will
lord,
not
it
do.
implies, my lord.
paragraph
the
10
next
of the
second-
single judge.
Yes,
Judgment says that he has written a letter,
yes.
right, to the management. These are
These are the, yes.
please recognize them, but his name was not there.
Unless he being a
That-
protector, that implies, my lord,
That,
yes.
that whether implies,
Yes, my lord.
that has to be, cannot be implied. Can you say that,
By-
you-
By document.
can you add some more force to your submission? Implies will not do, is deemed to be. Can it be said? Because he has written a letter,
Yes.
single judge has observed,
In the capacity of a general secretary.
general secretary, and has written that these are the workmen who should be recognized as protected workmen. But conspicuously, his name was missing,
That's missing.
right?
Yes.
So management might have recognized him
Yes.
or not recognized him. Question is, single judge observation is diluted by the division bench. So before the proceeding, the question is, first issue is whether the management of Steelworth is justified in stoppage of work of Sri Bachababu with effect from 5/1/2005. Otherwise, if he is not protected, then there is a transfer order. Transfer order, normally one has to obey the transfer order. If it is not,
In that also.
if it is not obeyed, despite repeated requests by the management, then it can be termed as a misconduct. As a result, management will get the discretion to pass appropriate order, which in the instant case, if your protection, your umbrella of a protection, protected workman is not there, then
Permission of ALC.
permission is not required.
Yes. madam.
It appears that is the, I think,
No, no.
position of law.
No, no,
Can
madam.
you say that
For-
general
for-
secretary is the protected one?
Yes, and that is a motion, madam. But
Because otherwise, had not been that observation in paragraph 10 been diluted by the division bench,
I am protected, madam.
if it remained, then it would have been depending. But the writ appeal was preferred only in respect of that observation,
On that observation, madam.
not against any other observation. Dismissal, they were not,
Only
Ah,
on that observation.
agreed.
madam. Yes.
they were agreed by the observation made in paragraph 10.
Yes, madam.
Yes, can you show that general secretary cannot be?
My lord, the lordship has rightly pointed out that so far the.
I don't know rightly or wrongly.
Lordship, because there is a reference of law, not other, that is, they have to write down and the management to accept it, also given a consent to that, these are the person to be accepted as a protected one. Now, apart from lordship, one important part is also that he is depending organizations, trade union, whether this organization registered or not, that is also one of the questions. Suppose this is not a registered organization, question doesn't have to, suppose invoke 33. at all.
What registered?
Because Manu, he's saying that he is the general secretary of the particular.
You have
management.
not raised anything. Have you
No, lordship.
have you said so anywhere?
No, it's-
Please tell me first, before making any submission, that you have disowned this trade union because you have continued with the conciliation proceeding with the office bearer of the trade union of Messrs. Steelworth Workers Union, led by Buchi Babu Singh, General Secretary. You have continued, right, with the conciliation proceeding before the Assistant Labour Commissioner. Now, is it open for you to make a U-turn and say that this was not recognized? Because you continued.
My lord, the question is that earlier round of litigation, no doubt, my lord, he has prepared on the basis of, my lord, his status, my lord.
Question is that only conciliation proceeding was on.
Right.
And that conciliation proceeding was led by Buchi Babu Singh as General Secretary, Steelworks Workers Union. and you with 3 officials participated in it during the conciliation proceeding, you passed an order of transfer.
Madam.
Now, if he is a protected workman,
Madam.
being the general secretary of that union, right? And in that case, there will be permission required from the Assistant Labor Commission.
Right.
If he is not protected workman,
Right.
then that umbrella
My lord, that will not apply.
stands removed. Then he will be an ordinary workman. And question will come whether terms and conditions of his service permits transfer. If it permits transfer, then because of his disobedience to the order of transfer by not joining in Tamil Nadu,
Right.
management may have the discretion to take appropriate action.
Right.
That is the only question.
Right, quite right. Madam.
So you have to address that by virtue of just being a general secretary of the recognized registered trade union,
My lord.
he cannot be termed as a protected workman unless this recognition has come from the management.
My lord, one aspect is very important to Lordship may kindly look into that while he raised the grievances at first round, my lord. That is his personal grievances, my lord. This is not a grievance that has been led on behalf of any organizations or the particular organizations or suppose addressing the common issues, my lord. He has been agreed and he approached before my lord, the authority about his dismissal part, my lord. Now, no doubt, but he has also added that he is the secretary of so and so, so and so. My lord,
Mr. Somoria, this reference was made.
Well.
As soon as this reference was made, you should have challenged it.
my lord. No doubt. my
Right.
lord, the concept,
So
my
that's please not there.
Correct.
Only issue boils down to it
lord. Now,
because of paragraph 10 observation being there,
my lord.
then you would have no case.
Right.
But that observation has been diluted by the division bench.
My lord.
So as a result, all things are open for both the parties. So we come back to ground zero.
Reopen the my lord, the whole issues.
So we are on ground zero.
But so far,
Only this thing.
my lord, only protected that my lord, worker that my lord, whether it tracks in a way of because my lord, the procedure, this is evident that.
MS
procedure-
Bhattacharya, have you gone through rule 64? Because I got the cue from that argument in the writ petition.
Yes.
Then I looked at it. In the writ petition order, can you see? Paragraph 4. Mr. Dekal, Senior Counsel. It starts and 1, 2, 3, 4, 5, 6, 7, 8 line. Rule 64 of the Assam Industrial Dispute Rules. Dispute Rules 1958.
You can fit.
Right. So have you gone through it?
I will have to take time, my lord. I will go through it, my lord.
Because if you are not protected,
Then my,
then have you joined or not? Because there is an order.
at,
didn't join.
Order is
at
there.
at Tamil Nadu.
1 minute. What is the order? A detailed order was passed after carefully considering the so-and-so award of the view. No interference is called at this stage as an interview. If the petitioner carries out the transfer order. Have you carried out?
No, my lord.
You did not
My
join.
lord, here, my lord, what happened, he has already attained my lord retirement age, my lord.
Whatever.
It is-
Oh, this order was passed on what date?
No,
It
is
was
okay,
passed
lord.
on 20 October
4,
2000.
3, 2013
Yes,
in a writ petition
yes,
at the motion stage while declining interim prayer.
yes, yes,
Court had observed
yes.
that it is however made clear that if the petitioner carries out the transfer order in terms of transfer order dated 27/11/2004 and the order dated 3/1/2013. 3/1/2013 means what? Which order? Award.
No, my lord, the order passed by this honorable court, lordship, the sequence of event, I have mentioned my affidavit in opposition, my lord.
Okay. Question of regularization of the service of the petitioner from the date of transfer till his date of joining may be taken up for consideration by the court.
That is after
Right.
the award, my lord.
If it is not done,
It is not done, my lord.
then we have to only see the transfer order, whether this reference. If the reference, two issues were framed.
My lord, page,
If the first issue is answered in a negative and against the workman, then there is no question of deciding the second issue.
the statement doesn't come, my lord.
Restatement will not come. Since you are a workman, that is why, otherwise.
So in this, my lord, I will pray for a time, my lord, for taking instruction, proper instruction. my lord. And otherwise, my lord, award impugned against.
What is that letter writing for recognition? Do you have a copy of that? Single judge has referred,
My lord, the
paragraph 10. Paragraph 10, please read paragraph 10.
As regards the plea,
Yes.
that the respondent number 5 is not a protected workman. Same is not at all tenable. He is the general secretary of the union, and it is he who had issued annexa 2 letter to the management, integrating the other members of the union in category of protected workman. So it implies, my lord, he is a protected workman. That is
No procedure is laid down.
maybe because he did not include.
Because
his
this
name.
observation is made without resorting to rule 64. Merely because he did not include. Anyway, this observation is gone. So only annexer 2 letter, that bears relevance, otherwise not. Yes, what to do?
So I will pray for time, my lord.
Well, is the evidence of MW1 is available here?
My lord,
One-
reports.
Baldev Singh,
Baldev Singh.
Baldev Singh, whether his evidence is available?
It's available.
Workman Management Industrial Dispute Written Statement.
Statement of affidavit of Sri Baldev Singh.
Workman Written Statement Management. Evidence, yes, evidence is available. 53, 54. He is silent about,
Silent.
he is silent about recognition of the trade union. In the evidence in chief. But anyway, they have recognized you before the conciliation proceeding. So far trade union is concerned and recognition of the trade union is concerned, there is no doubt. But recognition as a protected workman, that is in doubt.
Yes, ma'am. That is the question.
Only thing that if that umbrella stands removed, then it is disobedience to the transfer order. In that case,
And otherwise, my lord, the award is also, my lord, it is bad, my lord. It is a
award,
purpose-
I will not say much.
It's a
It is
purpose-
very
purpose
tough
finding,
to
my lord.
understand the language.
Yes, ma'am. That is why it's a purpose award, my lord. Whether your lordship will set aside the award or not, my lord. From the face of it is a purpose award, my lord. On
That
that I
is
will-
why, I have
Yes.
asked you. Otherwise, the award is against you. He has discussed everything.
Yes, but.
Just because one finding is perverse,
Yes,
that does not mean that all the findings are perverse.
so I will try to satisfy.
He has said that transfer order you have is an incidence of service or condition of service,
Yes,
and you did not obey to the transfer order. And he has referred to all the letters of the management,
and whether, my
refused
lord-
envelope, all these,
Yes,
right? So to that extent, it primarily appears that there is disobedience. And disobedience might have amounted to misconduct
And whether.
and that stoppage of work, which led to stoppage of work. But if you are protected, then it is different.
And otherwise, my lord, whether.
Then they had to approach
Yes,
the ALC first, that please grant us permission to transfer it. Otherwise not. 33 is only about that.
yes,
Otherwise, the issue is about bonus,
Yes.
not about transfer.
not about transparent. Is money for my lord, the payment of bonus, my lord. Conciliation was on that bonus, my lord.
On that bonus, but
Yes.
he is
But
actively
to-
involved.
To avoid him, my lord, from the discussion, he was
Right.
transferred to far off places.
But
And whether that is justified, my lord, I will try to convince you.
law has to protect you.
Yes, my lord.
If the law does not protect you,
Yes. No, whether, my lord, workman of such a status, whether he should be transferred to far off places, my lord, whether it is justified, my lord.
yes, there are
That
decisions.
question is also
I have
there,
come
my lord.
across decision that
Yes.
when a transfer order is made, one has to join the place of posting. And thereafter, he can hesitate the issue. In case of workman also, labor also, or in case of government servant also, the position is same. Unless you are protected by law. Day after tomorrow,
No, my lord, 10 days time may be given.
oh, 10 days time, I have heard, I have,
I will
You
have
go-
to.
try to,
I will have to
It has
contact my client.
no, 2013, not required to contact the client, you have to consult the law only.
Oh, my lord, whether.
Lordship,
whether that-
another
that-
point,
Whether that
Rohita.
paper is with him or not, my lord,
Huh?
that I will have to take instruction.
Day after tomorrow.
my lord,
It-
better to
it-
finish.
short.
No, I have. Because these are top of the list category, no.
No, my lord.
No,
on
Lordship,
Thursday, my
second
No,
lord,
point,
not permitted. Otherwise, I am going to.
On Thursday, I have difficulties, my lord. Any other day except Thursday, my lord. On Thursday, I have some personal difficulties, my lord. So I pray next Tuesday, my lord.
No. I have to
next
see.
you take this.
Only on the point of law, nothing else. 19 then,
19.
okay.
My lord, my another point is also about the maintainability of the read petition, my lord. That may also be, I think
Why?
they have. Lordship, 226 is not attractable, my lord.
226 is attracted. Whether certiorari jurisdiction will be attracted or not, that is.
My lord, the recent judgment says that in such a disputed facts, my lord, read jurisdiction.
What is this? Point of law is
The
involved.
point of law is there, but my lord, so far the judgment is concerned, my lord, both sides, my lord, has their own argument on the, my lord, certain points. The question is that, my lord,
Whether he will have no recourse, legal remedy.
no, legal remedy.
Would you
yes.
want to say?
No, absolutely not. My saying that, my lord, the judgment which I am positing, my lord, it's clearly said.
Delivered by Justice Emarsa.
My lord, it's a recent judgment.
Emarsa, Justice
That
Emarsa.
is there, my lord, some reference, but.
Now
it is-
tell me who has rendered the
My lord,
judgment?
this is a Jammu Kashmir judgment, my lord, High Court judgment, but.
Oh, Jammu Kashmir.
No, my lord, that reference is there, my lord.
Show me the Supreme Court.
This is
Part A
8,
for the
2028, 23, my lord.
Jammu and Kashmir.
No, my lord, that reference is there, my lord. The Supreme Court.
Read the Supreme Court judgment. A Bharasaiji. And Mr. S. Somoria. But as for number 1, anybody? I think Labor Court is not to be represented anyway. Mr. Z. Bokolial. Learned Counsel for the respond number 2. As sought for by MS Bharasaiji, Learned Counsel for the petition and leave that case on so and so. Next Tuesday. In the top of the list category. Rule 64, only that is important. 7, 10. Oh, 7, oh, 10. Okay.
Please, your lordship, this is the same connection, water connection matter. I have the part after I got to know, new facts came into light. And I got to know my position vis-a-vis the others. I have included the others also. All the other 6 who have been declared successful. And this is by basically including them. Facts are more or less the same. It only shows how the calculations were arrived at, how there was total non-application of mine. I bring your lordship.
Yes.
Lordship, the evaluation sheet, which is at page 43, that was furnished to us by them in the previous read. And lordship, if it's worked out, I have worked out the evaluation sheet taking my numbers into account. Now, lordship, there are 2 aspects here. One, they say clearly that petitioners who have not, the tenderers who do not meet their norms, minimum requirements, their marks will not be taken into account. But while calculating the numbers, the
Where is the provision that
lordship, that is in the page 32. If lordship looks at that,
32. Evaluation criteria.
Evaluation criteria is given there. The highest value among all bidders meeting minimum quantity requirements will be awarded maximum mark. Weighted marks shall be awarded to other bidders. For example, they've given how it's to be worked out.
If firm A submits highest number of, say,
It says
among what are
500
marks
amongst all
will be
bidders. Marks given to firm A is 30. Number of firms B is equal to
Mr. Bora, it should be 5,000, I think. Wrongly, 500. Page 32.
no 5,000. They give an example.
No. See, there is something wrong. If firm A submits highest number of HSC means house service connection
connections.
of say 500. HSC among all bidders. Marks given to firm A is 30. Now,
30.
number of so and so maybe HSC by firm B 4,000.
Yes.
Then he'll be given 24. So it should be 5,000.
No, 5,000 total.
So you have wrongly typed this formula.
Lordship, mistakes are all over, even while
Okay.
calculating. Mistakes are.
Okay.
No, lordship may look at the minutes of the meeting. Minutes of the meeting is again a little
Okay, base 38.
page 38. Here, it's maybe clearer. I think the formula is the same. The highest value among all bidders meeting minimum qualification requirements will be awarded the highest marks.
Okay. Weighted marks will be given. got
Weighted
it wrong.
marks should be awarded to all other bidders. If firm A gets submits number of HSB say 15 among all bidders. A is equal to 25, number of work,
Now it is clear.
this is clear. But here they made it clear that in 32, they made it clear that only of the highest value of the amongst all the bidders meeting all the requirements would be taken into account. Now, Lordship, I'll just point out how this is worked out. This theory is very simple, but Lordship will find that while working out this, say, I will say it was something.
To me,
BD. Now this
the 4 bidders. it doesn't be-
this person called D Kumar,
Hmm.
he has not qualified, Lordship. From the minutes of the meeting, Lordship will find that D Kumar has not qualified.
Okay.
And I give the statement with how I have worked out, it's at page 19. 19, Lordship will find. Of course, there's a calculation. We made so, but the highest, he is disqualified, but he has been given the highest mark in the category
Page.
page. House, this is for value of work or executed. Value of-
Page, where it is?
At page 18, but Lordship will get it
18.
18. I have worked it out from this chart, value of work executed. And taking his mark as the base, the marks of the others have been given,
Page 18.
18. Lordship will find in page 18, among the successful bidders, no one has got 30. But 30 is given to number 4, D Kumar, at page 43. He has been given 30 marks. Second large column. Lordship, after this, Lordship goes to page 43. Lordship
Yeah.
will find at column 4, D Kumar. He is disqualified otherwise, but for this, he has been given the highest mark, that is 30. 30 he has been given, and the other values are work, taking his value into account.
So this is a mistake they have done.
Yes, and
So
that,
if that is redone,
so entire.
whether your
equation will
position will change.
That is one, then lock structure. I have there now again, Lordship will find my position. I have given in this for page 18, Lordship will find years of experience. Lordship, my years of
Page 18,
page 18.
1/8.
One.
Which
Page
table?
page 17, sorry. Years of
Page 17, years of
Page-
experience.
experience. My year, I have been
Years.
given. I have been given 2, whereas from the evaluation sheet. And what I submitted. How is
Actual number of actual number of years. This second table is your claim.
This is one, and,
No,
and
first table is they have awarded, right?
Hmm.
Page 17,
uh,
they have awarded the marks.
yes,
And
Second-
second table is your contention.
yes. My contention, and Lordship again will find,
Okay, you want to say how much your marks are to be given to you?
our have been given 12.5.
Yes, as per evaluation sheet. Remarks. Okay, you want to say that
I
it should
got
be given 25.
25, I should be given 25.
Okay.
So Lordship, there is a mistake. Now Lordship, this another very, very vital mistake is the number of household pipe connections.
Page. Okay.
Page 15, number of household pipe connections. Household connections. Lordship, this have been given. As far as
Page
I am,
15 number of house connections.
yes,
Who scored highest? Messrs. Bhaskar Borua.
Bhaskar Borua. And Lordship will find that my household connection has been given as 1330. 1330. I have been given 4.86 marks.
Wow, 4.86.
Yes.
Okay.
But and whereas my household connection is 4231. And this they have accepted. This they have accepted because
12.5.
the value kahan hai na? Household value. They have taken as one.
You have submitted document in support of this,
Yes, Lordship, my documents are here. I have extracted.
part of the bidding document.
Yes, I've extracted part of the bidding documents. Lordship, I just take Lordship to household connections in my bidding document. Lordship will find at page 47. These are my household connections. 2350, 551, 480, 850. And Lordship, while calculating the value of the household work, they have taken this corresponding value. They have accepted the corresponding value. But household connection, how they got 1330, 1330, it is not decipherable. Lordship. It cannot be, it's not clear. So if all these things are together, I am in. But the point is, I have done only with reference with my marks because I know. The marks of the others, I do not know.
No, it is there.
No, Lordship.
No, you do not know about their supporting documents.
Supporting documents. So if they do all the supporting, if they do the exercise all over again with due diligence, then I think the matter would absolutely be clear.
So far, this B. Kumar and company, it is clear.
It's clear.
He should not have,
His
his marks should not have been calculated.
taken as reference.
And as the base mark for calculating others'
Absolutely.
marks.
Absolutely.
It is clear from 43.
Yes. And my household connection is also very clear, Lord. Because the value they have taken only in calculating numbers from where they got 1330, I cannot fathom. Then again, the number of years of work, the value they have taken for all these years, but the number of years they made it to. That is a very, very random thing which they have done with total non-application of my terms.
Yes.
In this case, there are two writ petitions. The first writ petition, it was not the details were given, to which we filed some affidavit. And after this, the second affidavit come with lot of details. So if the other side wants to, they can withdraw the first petition. In the second petition, we'll file a detailed affidavit so that the actual picture will come before this honorable court.
But there is prima facie
If it is
some discrepancies in
It
page
ha-
43.
lordship,
Because you have declared this man, D. Kumar and company, that he does not meet minimum requirements.
lordship,
And as per table remarks, page 38, highest value among all bidders meeting minimum qualification requirement will be awarded the highest mark.
lordship.
So he does not meet. So you have awarded him 30. And you have calculated others' mark on the basis of 30.
So
And we do not know about the supporting document, but since they have claimed, at least 6-1 should be
definitely.
6-1.
The record,
This is parallel contract. 6 persons have been
Yes.
listed. I am not disturbing
The
5
top 5.
because one has to go out.
Yes.
If he comes
Yes.
in the fray, then one has to go out and
Definitely.
definitely it will be the last. 25,000, no issue.
Yes. Remaining 5.
5,000.
yes, but-
6th rank,
yes.
no work order should be issued to the 6th rank.
The 6th person, lordship.
6th one, 6th,
Sixth one,
I
yes,
think,
yes.
you have
Yes,
listed,
Yes,
you have listed.
I've listed. I've made
No,
a
no,
note.
no.
Yeah, loyalist.
That bid evaluation committee,
They have given 5.
Yes, Lordship, and
this SS Enterprise,
Yes.
who is respond number?
that's one number 6.
No, respond number
Huh?
8.
And that's one 8, sorry, 8.
Respond number 8. I think he should not be permitted to continue
Lordship,
till the returnable date.
Lordship.
If you can make out a case that
Yes, yes,
petition is out.
Lordship.
Lordship, I'll take, the steps I can take only on numbers 8 registered post.
No, you're issuing that because if this D Kumar goes out, every marks will be recalculated.
Every month, and Lordship, if the records are shown.
We are not deserving top rank as on top 5.
No,
I think that is the best reasonable way out.
Lordship, if the records with some of them who got the tenders, they were registered with APDCL and PWD. Now, these people do not do household, water household service, they do not do. So where their marks came, even that I do not know. So it's very essential that the records may be brought on the next stage.
Advocation is appearing, he'll
He will
look
bring
into
it.
it.
The records will be kept ready, Lordship.
Mr. Bora will have it. You will have a look.
Yes,
You will
Lordship.
have a look about the documents given by them,
Yes.
by the other participants.
Yes.
But so far, 6th rank is concerned. We are not disturbing 25,000, only last one. He might go out if you become successful.
Yes.
Heard MS M. Hazarika, Learned Counsel, Senior Counsel, assisted by M. Lawyer,
Yes.
and Mr. D. Poikia, Learned Advocate General, Assam, assisted by Mr. S. Bora, Learned
Standing
Standing
counsel.
Council, Housing and Urban Affairs. Housing and Urban Affairs,
Yes.
Department
of Housing and Urban.
Department of Housing and Urban Affairs.
Dohua. DOHUA.
Okay, more to go you, huh? Piece of video.
1 and 2.
Okay.
1 and 2.
You withdraw this petition?
Let it remain, how does it matter? I mean, Lordship wants me to withdraw, I'll withdraw it. No issues.
No, no,
No, otherwise second it is not maintainable.
I can withdraw, it's all right, I'll withdraw it.
then look, okay, 17/8/2023
No,
order to
Lordship,
us, na?
if they come up with a contrary affidavit, I can do. That's, if they come up with a contrary
It is
affidavit.
always a part of the record. It is sworn on oath. You can definitely get a certified copy and annex it with your petition,
Absolutely.
your affidavit reply. Why adding the numbers?
I'll withdraw that, that does make
Here,
sense.
paragraph 2 to লিখে দিব। আগে order to 17/8/2023, paragraph 3 to লিখে দিব। Paragraph 4 to লিখে দিব। Paragraph 5 to লিখে দিব। Paragraph 3 যিকেইটা নাম আছে ন পূৰ্বাঞ্চল এন্টাৰপ্ৰাইজ ভাস্কৰ বৰুৱা তাজুদ্দিন সানৰাইজ KBS ব্ৰেকেটত ৰেসপন্ড নাম্বাৰ কেইটা লিখি দিব চাই পেলাই MS Hazarika, Senior Counsel has contended that though the technical evaluation criteria contained in clause 2.2.1 of the instruction to bidders ITB had prescribed that the highest value among all bidders meeting minimum qualification criteria requirement would be awarded maximum marks and weighted marks. Don't like. Weighted marks would be awarded to other bidders. Full stop. The minutes of the tender committee meeting held for evaluation of the bids on 18/7/2023, disqualified 4 of the 16 bidders on the ground that they did not meet the minimum requirement. Full stop. One of such disqualified bidder was D. Kumar and Company. Full stop. It is submitted that when the calculation sheet was received by the petitioner, it was found out that on the requirement
Value of work.
value of executed works, Messrs. D. Kumar and Company was given the highest mark of 30 and the weighted marks for the other bidders were given on that basis. Full stop. It is further contended that the petitioner was given lower marks than it was entitled on under the heads 1, actual number of connections, and actual number of experience.
Yes.
Experience
Work experience. And value of work.
as to stop. The petition was given 4.86 and 12.5 marks respectively on those heads. And the petitioner has contended the petitioner ought to have been given 15.44 marks and 25 marks under those two heads. Full stop. Mr. Hoigel and its advocate I have submitted that. So for D company, I can say, I will not say about the other,
Lordship,
only D company.
because there is a pleading on that also.
Insofar as the marks given to the allegedly disqualified bidder, here is it, Messrs. D. Kumar and Company, that might require reconsideration. To stop. Insofar as the other contentions are concerned, the same would be would require examination. To stop. Issue notice returnable.
2 weeks time may be given.
Okay, returnable on
2 weeks.
as Mr. Bora is telling now. Department of Science has appeared and accepted notice on behalf of the respondent number 1 and 2. No formal notice need to be issued. Extra copies, 2 working days. The petitioner shall take steps for service of notice upon the respondent number 4 to 8 by registered post with AD within 2 working days. I think that will not come
3 to 8. Lord.
3 to 8, but registered post will not come within 2 weeks.
I think Dusty then, Lordship.
Dusty will be better here because
Dusty.
there is a public interest.
As MS Hazarika has submitted that the petitioner may also be permitted to take steps for service of notice upon the respondent number 3 to 8 by way of Dusty also. So, Dusty compliance affidavit, 2 weeks. Having a regard to the submissions made on behalf of the petitioner and the on a look from a calculation sheet from my next with an extra 5 to 30 petition, it appears that Messrs. D. Kumar and Company, who was declared to be a disqualified bidder, was given the highest mark under the head value of work executed, and the other bidders were given marks on weighted basis accordingly. Full stop. There arises a possibility that the positions of the 6 top ranked bidder might undergo change. Full stop. The petitioner has further contended, since the petitioner has further contended that its marks on the 3 heads were incorrectly given by in the calculation sheet, it is provided that till the returnable date, the respondent authorities shall not notification of award of work.
House service.
It is provided that till the returnable date, the notification of award made dated 5/8/2023 within bracket annex R4, insofar as the 6th ranked bidder, that is respond number
8.
8
Yes.
shall remain suspended.
Deeply obliged.
MS,
This-
this one we close.
Close without prejudice to my rights, because res judicata may come in.
MS Hazarika. নাম কেটে লিখে দিব। MS Hazarika has submitted that since the petitioner has at a subsequently challenged the notification award dated so and so in a writ petition 5201/2023, the petitioner wants to come out without prejudice to withdraw the instant writ petition. So stop. Any objection?
No.
Mr. D. Hoytian, Advocate General Assam, the state by so has submitted that the state respondents have no objection to the state prayer in view of the above submission made by MS Hazarika, Learned Senior Counsel for the petitioner. The writ petition, stands dismissed on withdrawal, as paid for.
Hello.
Should be right closed instead of with business. Closed.
Stands closed,
Yes.
as paid for. This means what is dangerous.
Word rich. Rig. Workover rig is a big truck with equipments and all. So the present cost is about 20 crores. My lord, your lordship, can you see page 22?
Yes.
This petitioner, my lord, there, this small unit, MSME unit, my lord, small. Page 22. Now your lordship will kindly see that he tendered at page 24.
34,
24.
20.
20. Hiring of 2.0 second line, my lord. Hiring of 10 numbers of workover rigs package. That means they are inviting tenders for hiring of
Which line? Which
10
part?
numbers of workover
Okay.
rigs.
Charter hire.
Yes, my lord,
Charter hire.
charter.
Hmm.
Contract period is 4 years. Page 25. 16.
Hmm.
Now page 38, your lordship, can you see? Exemption from submission of bid security. A, MSE units, manufacturers so and so eligible for exemptions of bid security shall furnish UDAM's registration number with UDAM registration certificate along with technical bid. I am qualified, so this certificate is there. We are not required to give any, my lord, bid security. Now your lordship will kindly see page 55.
Yes.
55, your lordship. This is the condition of the tender, my lord. We hardly, my lord, it's very in rare case we are required to challenge it, my lord. This I find, my lord, this is arbitrary and it has been done in such a manner so that MSME unit doesn't come into picture. 7, my lord, your lordship has seen, my lord. May I read this? 8, man. 2.28, man. The bidder shall confirm to provide minimum 2 or maximum 5 numbers of complete workover rigs packages as specified under section 2 and 2. If the number of acceptable workover rigs offered by any bidder is less than 2, such bid shall be categorically rejected. So I have got only 1 rigs, 1 workover rig. So I am not eligible. 2019, my lord, due to COVID period, I'm just saying, my lord, 2019 COVID period rigs were available. So this condition was there, but I could do it because my rigs were available in lease. Because COVID period, people went off, leaving their rigs. So there was no complaint on my part because I have my 1 rig. I'm the only MSME unit in the country, my lord, which possesses this workover rig. Now your lordship will kindly see page 307. This is an invitation of bid by the ONGC. Similar nature of work. Description of thing, serial number 3, charter hiring of 5 numbers of workover rigs for various onshore asset basin of ONGC. There is no condition of minimum or maximum number of supply. So accordingly, petitioner got it, my lord. Page 303, he got an order from the ONGC. Now it is expired. 1 rig. 303, petitioner, page 303. This is the order from the ONGC in respect of the petitioner. Now the period is over. Now it is free, my lord. Petitioner is working with oil. Now, last sentence here, last page, your lordship will can you see? Page 321. At 322, man. The small enterprise, Roman 2. This is in exercise of power conferred under subsection 1, red weight, subsection 9 of section 7 of Micro, Small and Medium Enterprise Development Act 2006, and in supersession of the notification of the Government of India Ministry of Small Scale Industries dated 29 September 2006, published in Gazette of India, extraordinary so and so, dated 30th September 2006, except as respect things done or omitted to be done before such supersession. The central government hereby notifies the following. Number 2. A small enterprise where the investment in plant and machinery or equipment does not exceed 10 crore rupees and turnover does not exceed 50 crores. So this unit has got, my lord, 5 years, 5 crores investment in plant and machineries. And earlier, my lord, they took a lease from one of the private parties and they participated with the oil mine. But now, my lord, since the rigs are not available, I cannot take it on lease. If, my lord, I'm not not allowed to participate in the process of tender, that means they are keeping MSME out of the box. So therefore, my lord, they my submission is, my lord, they have deliberately done it so that, my lord, small scale industry they cannot participate, and that is, my lord, that is arbitrary.
Where is the mandate that for rigs, I mean, small scale industries are
They
required
have
to?
tender process itself, that condition is there.
Yes,
That security bid is not required.
Yes,
So therefore,
exemption is given
yeah,
for beach security.
yeah, bid security is not there for MSME. And MSME's turnover is 10 crores. If you go beyond 10 crores, I am out of this MSME. So now therefore, my lord,
All these tender clause can be changed.
my lord, it is
for that reason.
arbitrary in a sense because why 2 and why 5? There is no reason behind.
It is for
What-
them
what-
to decide.
No, but why 2? Why not 3? So therefore, they are aiming somebody else.
Why not 2? Why not 3? We are not going to decide.
Not yourself. No, I'm not leaving it to your lordship, my lord. I'm leaving it to my lord on general proposition that somebody says you supply only 2 cars and maximum 5 cars. There must be some reason. So therefore, what I submit, my lord, your lordship, subject to what your lordship is saying. Tender is opening on, then the last date of submission is 14th. I may be allowed to participate because all other conditions are fulfilled. All other conditions, whatever conditions are there, I fulfill that conditions. And only thing is, well, let them consider whether this MSME actor, they want to keep it out. Let them consider that aspect of the matter. In the meantime, let me submit my tender. The lordship will take after 10 days and clear the matter. Subject to whatever conditions you may like. Otherwise, this MSME sector, I have written my lord,
Yeah, there is no bar for submitting the tender.
no, that's part, because unless you do that condition, my lord, you will rectify.
That is the qualification,
That is what it is,
eligibility.
2. Minimum bid has to be for 2 and maximum is 5. I cannot give a minimum bid for 2. I have only 1.
We cannot tinker with the tender
No,
clauses
I'm not
unless
saying-
it is
No,
it is violation of any statutory provision. Otherwise, this is,
my lord, what I.
it is non-statutory contract.
No. If it is in a tender conditions, your lordship will not interfere unless it is arbitrary and without any reason. Because this
Arbitrary
condition.
thing can be examined at a later point of
Yes,
time.
So therefore, what I am submitting, my lord, let me submit my tender. Your lordship will let them also consider whether my representation is there. They have rejected it. In the line of MSME Act, let them
What is the
consider it.
rejection?
One line rejection, my lord.
Where is that?
300.
Page 300. They have not considered all this, man. Sorry to bear some, welcome to their building. Would you? Pick up to the one, very good.
Changes in the tender terms.
Yes. Seeking time for extension against so and so charter members of so and so. With reference to your so and so, please note that your request for change in tender terms and request for further extension of bid closing this cannot be. I'm not seeking any further extension, madam. That change the tender term. You are requested to submit your bid within the scheduled time and close it. They have not considered anything. This is an MSME, not only MSME unit having this work over rig. In the entire country.
Just because you do not meet the eligibility.
No, Malad, there is
How can
in the
we-
condition, in the condition, there is a provision for participation of the MSME units without any security deposit. This condition is there. That means what? MSME unit, they are entitled to get,
Mr. Das, when you- In the earlier round, when 2 rigs were required to be offered,
Yes.
you got the contract
No, that-
by getting 1 rig on lease.
That is an.
It is your own version.
Not 1. We participate in 2 because my lord, in COVID period.
That time that clause was not objected to
No, not.
because rigs were available for hire.
No, things were available for that.
Rigs were available for hire. Now just because,
No, because that is a COVID period. That was a
Whatever.
COVID period. All this, my lord, work over. rigs were
right,
available.
just now you are interested to get a rig on hire, but since it is not available, so you are challenging this term.
No, so it's challenging because my lord, that period was a COVID period. Your lordship will kindly appreciate that.
Where is the scope for interfering with the terms and conditions of, unless you have not shown any statutory provision?
Statutory.
Since this is a non-statutory contract, firstly. Secondly, it is not governed by any statutory provision. This is for, this last page is for declaration of MSME, small, medium or micro.
Yes.
That does not mean that you can qualify, you can participate in every tender process.
Every tender process, my lord, here, what they have done in ONGC also, they have.
I have seen
Yes.
5
tender, Not 5,
5 rigs,
5 rigs, but you can submit with.
one, here it is 10.
Here,
Maybe,
10. So therefore. they are
maybe
saying
it is easier for them to handle fewer number of
also therefore-
contractors instead of 10 contractors.
Therefore. what
They
I-
can either handle 2
Publicity
who are having 5 rigs or 5 maximum.
Your lordship will kindly see the judgment that Michigan, rubber India. Your lordship
Michigan,
will-
yes.
Yes, my lord, 2 conditions, my lord. Whether the process adopted or decision made by the authority is bona fide or intended to favor someone, or whether the process adopted by or decision made is arbitrary and irrational. That the court can say that the decision is such that no responsible authority acting reasonably and in accordance with relevant law would have reached, whether the public interest is affected. Public interest is affected by not allowing this
Why?
MSME unit to, by not allowing this only MSME unit in the country to not participate. So my lord, so therefore, what I say, my lord, there is no requirement of statutory violation. If it is arbitrarily or if there is no reason for my lord, for participation in minimum 2, my lord, it can be, there is no reason, my lord, why 2? That means they are targeting the bigger or some persons who are known to them, who can fulfill the.
Come to Michigan, paragraph 19.
19. But concluding parts is that, my lord.
No, there is another decision
Yes.
in the matters,
In the matter
association of registration rates,
of a tender document.
in the matter of formulating conditions.
Yes. In the matter of formulating conditions of a tender document and awarding a contract of the nature of ensuring supply of higher security, registration plays greater latitude is required to be considered to the state authority. Unless the action of the tendering authority is found to be malicious and misuse of its statutory powers, tender conditions are unnecessary. On intensive examinations of tender documents, we do not find that they violate equality clause under Article 14 or encroach on the fundamental rights of the class of intending tenderers under Article 19 of the Constitution. On the basis of the submission made on behalf of the Union and the state authorities and the justification shown for the terms of the impugned tender conditions, we do not find that the clauses requiring experience in the field of supplying registration plates in foreign countries and the quantum of business.
Same is paragraph 23, clause C.
Reasoning. Yes,
And
my lord,
clause
your
C and D, Michigan. Michigan goes against you.
lord- No.
Paragraph 23.
Paragraph, my lord, 23. is
C
the
and D.
concluding part. Concluding part 1. My lord, the reasoning, your lordship will get satisfaction when they submit the reason. If your lordship finds that the reasoning for minimum supply of 2 tender is good, my lord, your lordship may say we will not interfere. The reasoning is required to be given by them. Because this condition, my lord, outright, my lord, rejects my participation in the tender, although I fulfill all other conditions. The reasonableness has to be seen on the basis of the, my lord, whatever they submit before this court. Why 2? Why not 10? Or why not 3? Why not 1? It is a, after all, my lord, it's a supply of truck with equipments.
Right.
If we go for bid for 1, then what is the problem? If somebody goes for bid for 5, what is the problem? If somebody has got capacity to supply for 3 items. there
We
should
are not sitting over appeal or the decision of the
reasonableness.
tendering authority in formulating the terms and conditions. Greater legitimate is to be
Terms
given
and
to them.
conditions, I know, my lord, it is very hard to, my lord, come before the court and see the thing, but what I.
Tender clauses,
No, my lord, public interest in the sense it is going to harm.
we
the
can
MSME.
examine the matter, but I don't think,
No, your
what
lordship
kind
will
of-
allow me to participate if your lordship, my lord.
there is no bar in participating.
No, your
Only
lordship
thing
will
is
say-
that because of a tender clause, your tender might receive rejection.
No, so therefore, what I submit, my lord, your lordship will allow me to participate, let them submit the reason within a period of 1 week, your lordship.
There
will
is no
decide the
question of allowing it. You are allowed to participate.
matter. No, but 2. Without, my lord, your lordship will see the.
I have
condition.
seen, I have,
condition,
heard,
your
but
lordship.
there is no license required from the court to participate.
That rejection is there. Order of
Rejection is there, what to do? What,
I leave it to Lord.
what can I do? Unless it is
My lord,
shown to
if
be,
your
see,
lordship-
there is violation of statutory provision, none.
No, violation
None.
of statutory provision is not
None.
required for seeing the condition.
Right. So far, that is, there is none. So we leave out that. Now, question is malicious or malafide.
Arbitrariness.
Arbitrariness, how do you define arbitrariness?
Arbitrariness is this, my lord, they have arbitrarily decided this number 2 and number 5. There is no reason behind. There is no reason behind it. That's why, my lord, I am submitting before the court. Let them show on what reason they have said.
You participate, Mr. Nair, you produce why, what is the reason?
Yes,
I'll satisfy from here only, bro, whether he has any right, my lord. My lord would see, my lord has seen that page 25, my lord. My lord, we have modified, we have done this, culled out these provisions to see to that, my lord, the contracts are executed in a manner required and the interference, my lord, work load is reduced, my lord. At the same time, we are also, my lord, going for the cost effectiveness because certain materials which are there will be common to this. Right? So there is a cost cutting also, my lord, here. Now, my lord would see, he is not required to pay. Bidders quoting for charter hire of 2 rigs, rupees 64. Then, my lord, 3, 4, 5. My lord has seen it. And, my lord, if he is quoting for 2 rigs, his experience criteria, my lord, is only for 1 rig for 1 year. My lord. We have not changed that, my lord. Then, my lord would see page 54, my lord. It is not that, my lord, the rig has to be owned by him. My lord will have 2. Or 3, my lord. The bidder who does not own the offered worker rig at the time of bid of submission may also bid with leased workers rig subject to meeting the residual life. So, my lord, he has been given that liberty that if he does not have a rig, he can always go and, my lord, have a lease. It's a question, my lord, beyond the court's, my lord, control or appreciation that there are no rigs available in the market. There is no material to establish that other than the statements made, my lord. He says he cannot buy. Fine, don't buy. But what about the lease? And, my lord, Michigan rubber which has been relied with, my lord, para 23C, it's very clear, my lord.
C, D.
D, both are very clear. In that view of the matter, my lord, if an MSME, what is he entitled to? L1 plus 15%. If he is not L1, if he is within that range of 15%, he will get that contract, my lord. Plus, he need not deposit the. So, my lord, for an MSME, if he have to, my lord, lay down the law, my lord will have to lay down the law that the tender conditions has also to be read into that. My lord, that will be, my lord, beyond the power of 226. The humble submission, my lord, if he wants to participate at his own risk, he can participate. Because in
Yes,
view of-
page 55,
that is the, he cannot.
clause Roman 6. If you do not have the worker rig, you may also bid with proposed purchase.
my lord,
He says he
propose-
cannot
propose
purchase, my lord.
lease,
See,
purchase.
offer is there just because you are an owner of a league that does not leave you outside the fray. You can get a rig leased, or you can propose to purchase.
No, I can take it on lease, I can propose to purchase, purchasing itself, my lord, will cost me 20 crores.
That's not
What-
the
That-
Away from the.
hardship
If
cannot be.
class
the-
1B contractor wants to aspire to become class 1A contractor, he has to
I
think
I'm
high.
not in a position, but no, I could not explain to your lordship properly. Well, my explanation is that, well, the present petitioner, he is that MSME unit, he has got plant and machinery worth of about 5 crores now. And if I go beyond 10 crores, I go out of the MSME.
Oh,
Now-
you go out of small, you
Very
will
small.
become
Micro,
medium.
Medium.
That is different thing, but I cannot. go
That,
at this stage.
is
No, Your
not
lordship will kindly say the benefit given for the MSME.
right. There,
Benefit this and plus 300. Page 300, your lordship will kindly see.
yes, beach security exemption.
No. another-
These are statutorily provided relief.
No, these things are there. Why do they want to avoid this one bid and two bids? They can always say, my lord, why, there must be reason behind it. Without it, because ONGC in similar matter, my lord, they have said, oh, no bar.
I have seen the ONGC also, five rigs. Five rigs, there it is 10 rigs.
My lord, yes,
It is
then
5
but
rigs.
there is no bar, then even one can go for one rig.
Tell me where we can
So
set
therefore-
aside a
No,
tender condition
Therefore, what I submit, my lord.
unless it is.
Their intention is, I think, certainly not that they will not allow MSME. I'm the only MSME unit in the country.
Right,
That's
that
the
does
job.
not mean you are allowed to participate everywhere.
No. But 2 rigs, I'll have to apply for 2 rigs.
Where is the bar for them to fix a criteria like this?
Not bar, but it just, they'll have to show reasonableness.
Reasonableness is not, is to be
They-
shown in a tender document.
Yes.
They will reply.
No, therefore, my lord, what I submit, my lord, if they reply, my lord, let them reply within a 10 days or so, a small affidavit. But I should be allowed to participate in the meantime and not to, my lord, finalize my design.
That is too,
Well, otherwise, it will
Difficult.
become infructuous, my lord.
what to do? I am also bound by the principles of law.
But the principal law is very clear, my lord.
Yes,
Unless
Michigan
it is
itself
reasonable-
cuts across both
Unless it is
both
reasonable.
sides.
CND.
Reasonableness has to be there, my lord. Reasonable has to be, your
This-
lordship will get the reasonableness only when they file a reply. Why not 3? Why the maximum is not?
For
7?
that, then you deposit 5 crore as bank guarantee.
5 crores. This is small scale industries, my lord. They will die.
No.
They will die. my lord.
This, what to do? If you want to stall this is also for the public benefit. It is not that oil is to be extracted, something like that.
No.
It is for public benefit.
For
You are project espousing private interest.
Not private. My lord.
When
MSME
public interest and
MSME
private interest are pitted against one another, it is the public interest.
MSME unit. This is an MSME unit will be out of the race. And they get the benefit.
Just because you will be out of the race, why should we?
My lord, if he has a rig, there would be more tenders coming in. He can always participate.
And pay
Why, my lord,
2 years.
insistence on this, that the condition should be changed?
Let them give a reason, my lord, why they have gone for 2 and why go for
No, I am not
1.5. My lord,
going
page
to ask
312,
for-
Page
let them-
312, my lord, your lordship.
But I don't think this is a really
Page
going to challenge.
311. Page 311. Your lordship will kindly see the office, because these are the benefits accrued to the given to the MSME unit.
Right, given,
Yes.
We have given the,
given.
And
if
under
he had,
the-
if he gives 2 rigs, my lord, and he comes within that limit, he'll get it, my lord.
under 2 rigs, my lord, I will not be able to give this time.
Just because you have not been able to procure one more rig, that does not make the,
One rig, my lord, I have said in the statement, it cost is 20 crore rupees. But what is the difficulties on their part in accepting one bid for one rig? That reason they will have to give, my lord.
but for that is not a case for staying the process
No, I'm
or
not saying-
permitting the petitioner.
I'm not saying
That-
for staying the process. I'm saying, my lord, what I'm saying here, my lord. With one rig, my lord, I may be allowed to participate.
You
Let them
allow-
give the
you-
reason. Let them give the reason.
We cannot insist for dilution of this tender condition at this stage. Hard, Mr. Vigilas.
That page your lordship will calculate that 312, that MSME benefit. In that case, I think your,
312, what is there 312?
that MSME benefit.
That is only,
That is there for bid security and all.
Yes.
we are
No,
giving, my lord.
Procurement of 25% share out of the total annual procurement by the central government.
Then he'll have to show, my lord,
Ministries,
that has not been
Department,
fulfilled.
public sector undertaking, or to be made from him.
So that they are not doing it.
Doing it. It said not in the
In
specified
this case also, my lord, not allowing out of the 10 weeks, not allowing a single MSME to participate. He is in violation of the MSME Act itself. MSME Act, my lord,
What will be the contract value?
contract value is about more than 20 crores.
They are having worth of 10,000 crores.
Yes, they are having.
So 75,
So what is-
25% is 2,500 crores.
Therefore.
That
what I-
is too far-fetched.
No, therefore, what I am saying, my lord, let them give the reason. Why, my lord, why?
They'll give the reason.
But I should
Then
be
if
allowed to
it
participate
is
in the men's
found to
circle.
be arbitrary, you can definitely seek damage.
No,
Then
that
you
is
have
a
been
different sector,
arbitrarily
my lord.
disallowed.
That's a different sector, my lord, different argument
But
altogether. my
page
lord.
55
But
is
it
clearly laid
is
down.
Clearly lays down, but this is without reason, man. Why
Region,
two?
show me any tender document where regions are assigned. We are fixing this
If your
criteria
lordship-
for this region and that region. Show me any tender document in the world.
My lord, your lordship will say.
Any tender document, tell me this query. That why they are required to show regions
This-
for.
This paragraph, my lord, I'm reading it again.
They are the best author.
No, they are the best author, but at the same time, your lordship is at
We can
ask.
examine, but how we can
No,
stop?
allowing me to participate, well, they will not take any final decision in the matter.
Oh, that amounts to.
As regard one rig, man. As regard one rig.
I'm not convinced, Mr. Das.
No, as regard one rig, they will not take any decision at least for 2 weeks. Your
That
lordship
cannot
will decide the matter, see the reasonableness. As
Let
regard
them
one
file.
rig,
If we found that what is the period, 4 years.
yeah, period of contract is 4 years.
We'll interfere if the region is not
No, no, but
forthcoming.
if they give the rig to all, my lord, then I will have no chance. There is
Then that
no
is
question of see, if your lordship wants to scrutinize the scrutiny of the.
No,
the
I have not
reasonableness-
found any privacy case for scrutiny.
Only reasonableness, but why two, why not one, why not three? There must be reason. And I.
It should be witnessed by unreasonableness.
This is why unreasonableness, my lord. If you are taking a stand whereby one MSME unit which is surviving in the whole of the country, who are in a position to.
No
participate in
prudent
the-
person would have come to a decision, then only it is witnessed by
Yes,
unreasonable.
No reason, but a prudent person.
What
will
does
not
Tata
say,
Silva
why-
says? Irrationality. No,
Why two,
it is
why
not there.
not three, my lord?
Oh, everybody can say that just because another view is possible,
My lord, some-
court will interfere.
some
No,
would Not interfering, but your lordship will see
No,
the
no, no, I
reasonableness
don't
in the
find.
matter.
but
Then your lordship will have to reject it, I think, my lord.
yes,
Yes.
a prayer for interim prayer will be rejected. But Mr. B.D. Das, learned senior counsel assisted by Mr. H.K. Mohan. Mr. Nair, you,
all for all, my lord.
Mr. U.K. Nair, learned senior counsel
Oil India Limited.
assisted by Mr.
K. Kolita.
K. Kolita, learned counsel for all the respondents. The petitioner is a proprietorship concern and is a small enterprise, registered under the Ministry of Micro, Small and Medium Enterprises, Government of India, as it has been given in a Udyam registration certificate within bracket annexer 1 as a small manufacturing unit. Full stop. Para by a invitation of bid within bracket IFB bearing number CDD page 24 3897 P24 for charter hire of 10 number of 550 HP within bracket minimum page 24 750 HP max walkover risk package, respondent Oil India Limited has invited international competitive bids, within bracket ICB, from competent and experienced contractors through its e-procurement site. Full stop. As per the IFD, comma, the type of bidding is online open global e-tender colon single stage dash two bid system. Full stop. The bid closing date and time are fixed as 20.
24,
It was extended or what?
It was extended, my lord, the last date now is 14/9/20.
Originally, bid closing date and time were fixed as 24/8/2023 at 11 hours. Full stop. Subsequently, bid closing date and time have been extended to
14/9/23.
at 11 hours.
11 hours.
Submission.
14/9, 14/9, no? 14/9.
Full stop. Para.
Yeah, take what?
The petitioner. Oh no, as per the IAB, the duration of the contract would be 4 years. Full stop. The petitioner has instituted a petition challenging clause 2.2 within brackets Roman 8 of the bid document, which reads as under page 55. It is the contention of the petitioner that it has the petitioner owns a rig but the respondent oil has fixed the criteria for a bidder to provide minimum 2 or maximum 5 number complete workover rigs as a condition of eligibility to participate in the bid. So Mr. Das, senior counsel for the petitioner, has contended that such fixation of eligibility is arbitrary and irrational. Full stop.
To keep the MSME.
And such a rigid condition of eligibility has kept a small enterprise like the petitioner, small enterprise under the Micro, Small and Medium Enterprises Development Act 2006, like the petitioner, away. Mr. Das has referred to another
Page 307.
invitation to bid within bracket resale, page 307, published by a similar published by Oil and Natural Gas Corporation Limited on 26/8/2003, a similar organization like the Respondent Oil, whereby open tenders on international competitive bidding basis under 2-bid system was quoted for charter hiring of 5 number of workover rigs for various onshore assets stroke basin of ONGC. In the said invitation to bid, there was no condition laid down that to the effect that a participant bidder had to offer a minimum number of rigs, like the one attached with the IFB bearing the IFB under reference here. Full stop. Where par contra, Mr. Nair, the senior counsel, appearing for the respondent oil authorities, have referred to clause 2.2 Roman 3 and clause 2.2 Roman 6 of the bid document. Full stop. He has contended that clause 2.3 and clause 2.2, 2.23 and clause 2.26 have allowed a bidder who does not own even a rig, to submit bid in response to the invitation of bid dated. What is the date? 10/7/2023. Stop. Just because the petitioner, a small enterprise, has not been able to offer 2 rigs, the tender condition laid down in clause 2.2 Roman 8 cannot be termed as arbitrary. Full stop. Where in response, Mr. Das, senior counsel for the petition, has submitted that the respondent oil authority, respondent oil as the tendering authority has to assign region as to why a bidder participating into bidder who intends to participate in the bidding process under reference, is required to provide minimum 2 or maximum 5 number of complete workover rigs. As no regions have been assigned, the decision to set forth such condition, such onerous condition of eligibility is clearly arbitrary and irrational. Well, issue notice. He has submitted that the petitioner
Your lordship,
may be allowed.
consider the interim prayer on the returnable rate. Rejections also.
Issue notice returnable on 10 days, 15 days.
3 weeks, madam.
Today is September.
September
28 or 29?
Lordship.
29?
Then
29/9/2023. First off, Mr. Das and senior counsel for the petition has also submitted that the prayer for interim relief should be considered on the returnable date post of issue notice. Also in the interim prayer, post of the respondents shall file their respondent oil authority shall file their response on or before the returnable date. Post of. You want to participate? Anything to be observed?
That my lord will not observe because that it's open for him, my lord.
Your lordship, there is no bar.
That is open for him, my lord.
No bar for participation.
That is open, my lord. Because that may again, my lord, create problems, my lord.
My lord, one.
Tomorrow
one
again, other interpretations may come in. My lord, it's open for.
You are there.
there.
No, but still, my lord,
There-
because
why-
what I'm trying to say is, there is, my lord, this only MSME thing will not come. If he does not qualify the condition, the MSME Act does not say that even you dilute that.
Why are you putting that condition?
That is my discretion, my
You
lord.
participate, you participate.
You participate, he can participate at his own weakness.
There is no bar, you can participate.
Boss, that's all. Because my lord, opening will create problems, my lord. My lord will not make an observation, it's open to him.
They can always do.
It's open to him, my lord. If he wants to participate, he can
It is
participate.
open to him.
Yeah. My lord,
There is
your-
no bar.
because of the order, your lordship, that there is no bar for the petitioner to participate. I may get one, my lord, Mr. Nair may give me one on this.
No, my lord, it cannot be.
Petitioner, it is, petitioner is as a petitioner is at liberty to participate in the tender process. And in the event, the petitioner participates, command the responding authority shall consider
In terms of the tender conditions,
the case of the petitioner in terms of the
tender conditions.
My lord, your lordship is
That
written
will-
all the submissions, my lord. Only one line, my lord, that it is tailor-made only to accommodate the big players.
Okay.
There is no such pleading, my lord.
It is.
Let them bring that on with material, my lord.
Pleading is that my learned friend has not read it. my lord.
I'm ready.
What is the harm? Okay, certainly, first part of it, that the tender conditions have been formulated in order to accommodate big players.
He says, my lord, the tender conditions has been made to oust MSMEs,
Yeah,
not
that-
the other way. around.
Yeah,
That has been, it's a-
My lord, that ONGC tender notice is 2013.
13, things have changed 10 years.
10 years.
2013, huh?
Lordship,
The correction, I'm saying.
extra copy, lordship.
Okay, as Mr. Kolita, learned counsel has appeared appeared for all the respondents, no formal notice need to be issued, Mr. HK. So, learned counsel for the petitioner shall serve requisite number of extra copies along with annexes to Mr. Kolita within 2 working days from today.
Obliged.
For hearing item number 5,
There is one part heard. Yes, one part heard is also there, 2013.
item number 5,
Is he available?
Yes, lordship, it's on its way.
And whoever, take away.
Hearing in fact was concluded on the
No, I
last day.
forgot everything. I forgot everything, just, you have to
Okay,
refresh, I forgot everything.
okay.
I don't have any,
No, then can it be on
Memory-
some other day, my lord, because I am also not prepared on them. Can it be,
okay, we can do it, no issue.
because lordship had raised the query regarding protected workmen, my lord. On that issue, I am prepared. I've got
I have
three-
also seen,
I have got three.
in the
judgments.
first case I have, today, which I have
My-
heard, I got the fair idea who is a protected worker.
My lord. I've
There
got-
is,
I've got one Supreme Court judgment, one our High Court division bench and one Bombay High Court single bench, my lord.
what does it say?
It says that the protected workman is only for the purpose of section 33. When there is a pending dispute, you cannot change the condition of service.
And from the arguments recorded there are two writ petition, one in the first item, second item. From that, I got the clue. Rule 64,
64 of our local rules.
which you, late PC Deka argued,
Even Lordship, Industrial Dispute Act also.
which late PC Deka argued, so I got the, he referred to 64,
61.
rule 64,
61 is of the central rules.
61 in the central rule.
but state rule,
State rules.
64.
Language is the same.
How the workman is to be recognized as a protected
Lordship,
workman.
Lordship. In central rule, 61 is provided there.
Now, what you have challenged here?
My lord, challenge is basically that it was an individual dispute sought to be referred as an industrial dispute
67,
because the union is not a recognized trade union.
67, 67. That is one.
My lord, may I pray one thing, my lord? Can we do it on 21st, my lord? I'll also prepare a brief note. My lord. To be very honest, my lord, I have not read the file yesterday. My lord.
Oh, I remember something and I do not remember something.
Now let us start afresh on 21st, my lord.
We have challenged another thing, the 3/6/2009. 3/6/2009, right?
Yes.
But that some miscases or ordered it 27/3/2019. 27/3/2019. 27/2019. Okay, 27. So this part, at your submission, response number 4 has been struck off. Response number, name of the response number 4 has been struck off. On, you made submission on 27/3/2019, right? Response number 4 is managed, that union. Downtown Employees Union.
It's not a valid, no longer a valid body, my lord.
No. What is that 3/6/2009 order?
3/6/2009 is the order vacating the cancellation of the registration.
So, page,
Page 59.
so that I think Mr. Deka, PS 59 challenge will not, is not required to be considered because 4 has been struck off. 4 has been struck off from the area of respondents. Now, in its absence, we cannot test the validity of this order.
That was also not put to silence.
No challenge. It is challenged. Page. See the prayer.
That is there, page
is
19,
fair.
page 19, Lordship is there. Lordship.
That part we will not, we are not going to discuss. Because you address on this point that this registrar cannot revoke, I think, an order of cancellation. Did it not? You cited some decisions also, Bombay High Court, right? So, in the absence of, because by this order, rightly or wrongly, illegally, whatever, this body got its registration back. Now,
3rd June 2009 order lordship,
what? See page 19, page 19,
19 lordship,
page 19, second line from bottom.
3rd lordship. And the order dated.
3/6/2009.
That is there lordship, it is there lordship.
So only we will have to test the validity of this 28/2013. Right?
Lordship.
Yes, Mr. Rekha?
My lord, one thing is there, my lord, because if that order is not challenged,
That is.
I may have, because this is.
Because
this
it
is
that is why I am
If your lordship sees-
indicating to you.
My lord, if your lordship sees the 27/3/2019 order, my lord,
Yes,
my submission is that it is further submitted that he has been instructed by the petitioner that there is no such employee union at present under the name and style. And requisite number of so the union has been cancelled. I know, I did not submit to struck off, my lord.
so in
Court
view
order.
of such submission, the
The
name
court
of
order,
respondent number 4 is ordered to be struck off.
It will be difficult, my lord.
Then
because
lordship,
I have
the
to challenge, I have to maintain the challenge.
Because otherwise, if the 3/6/2009, there because of this Bombay High Court judgment, you have said that unless it is set aside in appeal or fresh registration, your submission, if I
Fresh-
remember correctly,
Fresh
then this
Fresh
registrar
Cannot
cannot
so-
revoke
cannot
lordship,
or order of cancellation. Now, in the absence of respondent number 4,
My lord, I will have to do something about this.
there was lordship that particular 28 order. also
no, in the
lordship,
absence of that union,
lordship,
whatever exist or not exist, as a respondent,
lordship.
this order cannot be decided by this court.
I have to do something about it.
Yes, sir.
So this is serious one, and this, if this,
This will.
some
cause
observation is not made in this connection, then your,
challenge to 3/6 will go.
Hmm.
And if challenge to 3/6 goes, my lord,
Then automatically
Everything
that order will go lordship.
right,
There is so difficult.
lordship will accommodate me today, my lord. I'll
Okay.
have to do something about this.
because it is a submission made.
Lordship.
So if that remains
Then
without challenge,
lordship.
then this body is deemed to be a registered trade.
Lordship.
Then I don't know what the consequence will be. Think about it.
Lordship will give me some time. I'll have to think it over.
What to do? We'll release it from Parthad. It will again come back to me only.
Lordship, lordship.
Okay. Yes, what will be a submission? I have to record.
That we have to file an appropriate application against the order dated 27/3.
Okay.
Lordship may record and I'm seeking time to file appropriate application.
Okay, Mr. N. Dekal, and counsel for the petitioner has submitted that and he needs to file additional pleadings in the writ petition in order to sustain the challenge by the petitioner to the order dated 3/6/2009. First one, Mr. K. Gugoi, learned additional senior government advocate, Assam, for the aspect number 1 and 2 is present.
Lordship, lordship.
First of all, there is no representation on behalf of the respondent number
5 lordship.
5. Full stop. The respondent number 5 was found absent on the previous date of listing, that is on 24/8/2023 also. Full stop. As sought for by Mr. Dekal and the counsel for the petitioner, lists the case. Yes, when you are.
After a week, no, next week.
Okay, this is the case after a week. Because it is, okay, this is after a week, after. a week.
It will remain as part-time, my lord.
No, the matter is released from part-time. Case is released from part-time because there is some bar also.
Yes,
We
that
cannot
is why.
keep it. That is why I have to release.
I think it is 3 months, my lord.
No, 1 month. I
No, I
don't.
think it is 3 months.
3 months.
1 month.
3 months.
Yeah, 1 month.
1 month.
Now 1 month, Lordship. Earlier 3 months was there.
Earlier it was 3 months.
Lordship.
Now it is 1 month,
month.
so I cannot keep it.
So 1 month from the date of hearing till
Start.
judgment,
Starts from here.
starts from the hearing.
So again, it will come back to me.
Lordship.
Most probably.
Lordship. Congratulations.
3 for this one.
My pleasure. But the matter, in fact, your lordship has heard on this some other day. Here issue is that, my lord. We are in settlement of fishery. Petitioner before your lordship, he was the highest bidder. But denying the highest bidder, last bidder was settled with the fishery. Challenging this order, the petitioner refused this court. This honorable single bench by its order.
Okay.
Then the order of single bench was challenged, division bench by way of appeal by the respondent. The division bench has referred the matter only on the point on the lordship, and this is the order of the division bench. Here the findings, here the only thing is that as regards finding, that the
Instant,
technical bit of the petitioner was found to be in order,
1 minute.
there is no reason.
The instant writ appeal has been prepared by the appellant hearing with respond number 7, the requisition being agreed by an order to pass by the line. Whoever the requisition prepared by the respond number 1 was accepted with each settlement of law and district made in was interfered. So the evidence is directly forward to the respond number 1 hearing. Being heard, the consider the submission settlement by the line of the party that going to the other matter is find that the bid of the appellant was accepted and the bid of 3 contenders in the response were rejected. On the ground of it was technically defective. The last have went on to observe the case in hand was considered to be technically sound bidder in his operating 9 was the highest and thus the contract was awarded. We find that the field of the bidder was from technically sound without assigning any region.
This is the case.
It appears the decision on the matter is made on the basis of the order passed in WPC and as affirmed by the division bench by WA. It was held that this is covered a compulsory. No discussion, however, no discussion. Parity. Okay.
The finding of the learned second, your lordship,
We will not look into that.
yes,
Not required. Required.
not required.
Set aside.
Only this one, whether, what is the ground that the holding that the technical.
Okay, any tender notice?
Lordship will find,
Any tender notice?
yes, sir.
Where is that?
Annexer 1,
An extra one.
page 13.
Page 13.
What thing?
Okay. Hot boss.
The below mentioned Meen Mahal under the Assam Fisheries Development Corporation would be settled for a period of 7 years, starting from the financial year 2021 through an agreement. Tender of bid is hereby invited in a sealed envelope from scheduled caste people belonging to fishermen community of the concerned district or registered Samvad Samiti consisted of 100%. Now the concerned fishery is my lord 58 number Lauban,
Serial number 3.
serial number 2.
Okay. Then what happened?
Now, then your lordship come to the page 5 of the petition,
Page
5 of the petition,
5.
paragraph 5.
Okay.
Altogether, 5 bidders have submitted their bid,
Hmm.
including petitioner and the respondent, private respondent. Now, after scrutiny, my lord,
Hmm.
that is page paragraph 6, page 6. I have given the table. The petitioner number 1, petitioner, respondent and some other 3 bidders, bid of the 3 bidders are found technically in order, and their bid has been opened. Now there is, according to this, I am the highest bidder. But denying me, the second highest bidder has been granted. Now challenging this, my lord, the writ petition was filed. So by the order, my lord, which was challenged before the division bench, the
Who is the settlement order?
settlement order, my lord, at that time, though I applied for, that was not given me. It was, they have annexed it in their affidavit, my lord. Page 17, your lordship will find.
Setting aside passing in favor of the students.
Page 17 of their affidavit, my lord. This is big volume. But here, my lord.
1 minute, let me have a look at page. Date of settlement?
22nd May 2020.
Oh, that one in person.
Here, my lord, one thing, my lord, I must mention that the order in page 17, though date and memo number is same, the record says this is a quite different order, but memo number and date is same. On that, my lord, the departmental council will address the court. Your lord, on the other day, your lordship permitted me to examine. I have seen this. The memo number is same, date is same, but order is different.
Okay.
In the page 17 order, it is said my technical bid was defective. But the
Okay, your technical bid was shown to be defective.
defective, according,
Okay.
this is their stand that my technical bid was defective. Therefore, finance, as per tender rule clause, that once, when some, to open the financial bid, technical bid must be in order. If my technical bid is not in order, financial bid cannot be opened. Their stand is that my technical bid was not in order. So, but record says, your lordship will examine the record. Record says my technical bid was in order and my financial bid was open. And upon opening of my financial bid, I was found to be highest bidder. But despite that, instead of this, the private respondent has been settled with the fishery. And on being such satisfaction, the earlier, the order was passed setting aside the settlement, and after this setting aside order, the fishery was settled with me. But agreed by the single bench order, they approached the division bench with appeal. In appeal, it was remanded. Only to examine this, what is the basis?
So, single judge order was set aside.
Set aside.
Okay, so it is
Not
fresh
set aside,
consideration.
only to ascertain that, because in my understanding, it was not wholly set aside. The division bench said that the reason finding that the reason of the finding that the technical bid of the petitioner was in order has not been mentioned in the order. So this is to be examined now as per the order of the learned, as per the order of the division bench. Whether my technical, what is the reason of holding that my technical bid was in order? My lord, for a moment, kindly see the order of the learned single judge. It is in the report.
Ordered on the single judge.
Yes, that is dated 19/4/22.
19/4.
22. In the middle of the order, my lord, may I please? In the affidavit filed by the respondent AFDC, lordship got it. In the affidavit filed by the respondent AFDC, it has annexed its process of settlement of fishery, which goes to show that it is a two-bid system. After technical bid of the bidders were found to be proper, the financial bid of the technically sound bidders are opened. In the case in hand, the petitioner was considered to be technically sound bidder. And thereafter, while opening his financial bid, he was found to be the highest bidder, offering 11 lakh for settlement of such and such fishery involved in the case. The division bench has taken note of this part, that what is the basis of this finding? There is no mention on.
No, division bench says why the single judge has drawn the parity. Parity. Division bench order. See the division bench order.
Division bench says, your lordship will find,
Division bench.
we find it, the said, the
However,
however,
no discussion was made by the learned single judge for drawing a parity in the facts discussed by the court in the aforesaid two matters and those prevailing in the case in hand. Anyway, then what is the stand of the AFDC? Any affidavits?
so
Lordship, affidavit was there, Lordship, in that case.
Affidavit, right?
affidavit filed.
Your
No,
respondent
Lordship,
number 2.
And the Lordship, in this case, if needed, Lordship, I will file fresh affidavit, Lordship. Here I have, if Lordship, kindly go to page number 17, Lordship.
This is a voluminous affidavit filed by the, my lord.
Page number
this is the
17.
affidavit.
Page number 17 of the affidavit, Lordship,
Page.
filed by earlier managing director, Lordship.
Is number 17.
And that, and
17.
Yes, Lordship.
That is the one.
Managing director.
Lordship, this is not, we could not find this order, Lordship. And the order record which we have, is a different order, Lordship. In that case, if we will give some,
What is the paragraph in the affidavit connecting to annexure 1? Paragraph 6.
Paragraph 6.
It is denied the petitioner was declared, however, instead his bid was found to be technically defective due to defaulted DPR or bill development and excessive exaggerated rate of fish production. In this regard, begs to state that in pursuance of the so 5 containers submitted therewith out of 5 containers, tenders of 3 containers were found to be technically defective, including the tender of the petitioner for the above stated region. And the same is reflected in our part. So that is your affidavit.
Yes.
That is your affidavit.
in that case, Lordship, today, Lordship, if possible, Lordship, I am relying only the records with these things. If possible, I will file an affidavit, fresh affidavit, Lordship, in that case. This is, we could not find any.
By traceability, what do you intend to do? Tell me.
Lordship, here, Lordship, intend to do, Lordship, that here, Lordship, in the original order, Lordship, what is there? In the original, as per the original order, Lordship, Lordship may, if Lordship goes here, Lordship, all the bidders, financial bidders open. So if it is open, it is deemed that technically it is depend. And here they are being, after being the first bidder, they are being disqualified, considering that fact that they have quoted higher maximum amount and which gives the parity to that WA writ appeal number 8/2021. That in that case, it gives parity. If this order is there, this order was also earlier order, Lordship, and here note sheet also there, Lordship.
Now, what do you intend to do? Tell me that on the basis of what submission you want to file that? Because this stands
Lordship,
as on date this affidavit stands.
Lordship. In that case, Lordship, I
By
will,
verbal submission,
I will give, I will, the record is that I will give.
you want to change the context of the affidavit?
No,
Tell me.
that
tell
part,
me.
that part I will have to.
Proper facts are not reflected or what? Tell me, only then I can,
Lordship, there may be something, Lordship, because
something will not do.
at earlier point of time, not now, Lordship, that is.
Tell me that the facts are properly not reflected in the affidavit.
Yes, Lordship, that may be,
Huh?
that may be, by this.
That is not proper, correct projection.
Correct projection, okay. Okay,
That is what you want to say,
Lordship,
because this is a statement on oath.
Lordship,
If you need something to be placed on record,
Lordship.
which is something different from what have been stated here, then there has to be some clarificatory affidavit, additional affidavit.
Yes. We have to
Otherwise, that
hear,
you are not relying on this affidavit.
No, at
Then
Lordship,
file-
Lordship, the fact is that at this point of time, the division bench relied on these documents, Lordship, and here, Lordship, the signature is also something different.
No, it is up to you to, we cannot decide all these signatures, right? It is, if the settlement
Lordship,
order is a different one in the record,
Lordship,
as you have said,
Lordship,
then you have to file the proper affidavit.
Lordship.
You do not
Contents is
want to
different.
rely.
And contents is different, memo number, date is same.
Lordship,
No,
yes, Lordship, kindly go through the
we are only read code, we decide on the basis of affidavits.
Another thing, already it is
record.
settled law.
Kindly, Lordship will be clear, kindly go through.
Long one.
Long one, Lordship. In the note sheet also, we found it was earlier, Lordship.
My lord, kindly compare the memo number and date of both the other.
Where from you are saying that this is the earlier one or correct one?
Lordship, as we have found from the record, Lordship. And here, Lordship, from the note sheet also, it was open from that order, Lordship. It was earlier in this signature earlier in this, not the present one, Lordship. He is under suspension, Lordship.
This return for the castle. Highest rated.
In the note sheet also, that this order is being reflected, Lordship.
Which note sheet?
This first part, from the first part, Lordship, first
32.
from the first entry also, the reference of the order is also there, Lordship, in vernacular, Lordship.
I find very difficult to read all these notes. It's
This has not been challenged also.
at what point of time you detected all these?
Lordship, only recently, Lordship. Recently, Lordship, actually.
Hmm?
Actually, when the single bench passed the order lordship, at that point of time, no record was there. And we have filed FIR also for record also. Record from the earlier officials lordship in the dispute police station during that period of time. We could not get many records lordship. And that point of time, while passing the single the order, the single just gone through this part lordship, that division bench order lordship. Only going to that order, this order was passed lordship, without pressing many record.
Because of this,
The lordship may accommodate me lordship for filing an affidavit lordship, fresh affidavit. In that case.
the case is listed before this court on many occasions.
Yes.
Now it was never said.
Lordship,
It was listed on 28/6/2023, 5/8/2023.
no, last lordship, I have indicated lordship.
Submitted, he has gone through the records, will make submission as regards the materials contained therein on the next date of listing.
Last
Right.
lordship, I have indicated lordship, lordship has gone through this record lordship.
I
Last
have not gone through. I have not gone through, you have submitted.
I have submitted, I have shown lordship. Lordship accommodate me, I will file additional affidavit.
What affidavit you will file? Tell me.
Placing this fact, lordship, lordship may pass any order, lordship pass truth. Only what is we have lordship.
So this is wrong. This paragraph, page 17 is wrong. According to you, that 5 contenders, 3 or number of contenders were found to be technically defective. That is wrong.
But this DPR development.
This original,
This original record we could not find. This, for this part, lordship.
and plus, in this order, out of 5 contenders,
Lordship,
3 number of contenders were found to be technically defective. This statement is wrong.
that part I can't say lordship. That part defective.
Then you have not gone through the records, you are making submissions.
Lordship,
Once earlier, at an earlier point of time, you made submission.
lordship.
Now you are saying that I do not know.
5 contenders, out of 5, 3 numbers contenders are found to be technically defective. Due to their defaulted DPR of development, excessive exaggerated rate of risk. Lordship, I forgot it, lordship, in the record itself, lordship. Just a minute.
Single judge has recorded,
Lordship,
records reveal all the 5 bidders
Hmm.
were found technically responsive,
lordship.
right? So you have to say, this order says
Hmm.
3 were defective.
Lordship.
Single judge has found all 5 technically responsive. So have you gone to the records as a standing counsel AFDC? If the standing counsel AFDC does not himself go through the records, why should we go through the records? Are you sure what kind of?
Yes, lordship.
Then let me see. You are not sure what the record contains. Where are the technical bits? Please at least identify me. Show me. Let us proceed. Show me, mark me. I'll see.
Lordship, I have regarding technical bits, lordship, what our lordship has inquired regarding. I have not won anything regarding technical bits, lordship. We could not find anything, only this order.
Mr. Sharma, I am standing as AFDC has submitted that he has gone through the records and will make submission as regards the materials contained therein on the next date of listing. This is the order passed.
Yes, Lordship. Lordship, give me 2 days time, Lordship. Here I could not find from the record, Lordship.
This is difficult, Mr. Sharma.
Lordship, give me, kindly accommodate me for
At
7
this hour, 3:30.
Kindly accommodate me for 7 days, Lordship.
Yes, Mr. Das, what to do? I recorded the submission of Mr. Sharma. I have already read out.
What I,
Because I do not want to go through the records unless it is necessary.
what I understand, my lord, I was the beneficiary, but was what I.
You continue. No stay order.
No.
I'm not
continue.
continuing now. After the
You
order-
continue.
Nobody is running.
Nobody is running.
Nobody is running. Because it was with me, but after the order of the division bench, it is stayed.
Status quo, Lordship.
On what day? Because I do not want to go through the
Lordship, I
single judge has said 5 bidders were found technically responsive as per the order.
Lordship.
And this impugn order contained in this case record says out of 5, 3 were found defective,
Lordship.
technically defective. Right? Both these are contrary findings.
Contrary finding, Mr.
So that is why I asked you to go through the records.
That is on the basis of the affidavit filed by the AFDC. That record, the order passed by the retapel is on the basis of the affidavit filed by the.
AFDC, Lordship, which is not in the record. Lordship, I will be in a difficult position to say that, Lordship. I will file through affidavit, Lordship.
That is on the basis of the.
It will be better, Lordship.
AFDC says that. See.
It is AFDC says earlier point of time, but
So
record
therefore-
says something else, Lordship.
therefore, Subject to what, if your lordship allows me to submit, I will submit, I have seen the record, even the impugn order which they are showing it here, order of settlement, that has not been challenged by anybody, neither we have the copy. I think we do not.
That is under challenge.
This has come mysteriously,
Mysteriously,
but anyway, the order made in favor of the respondent is challenged.
challenge, but.
Challenged.
but No, but.
It's something which cannot be accessed by the petitioner.
Yes, so this has.
He has substantially challenged the order of settlement made in favor of the private respondent.
That's good,
Now, if
What-
something mischief is committed
committed, yes.
by the AFDC, how can an outsider get access to the
Lordship.
file? He has,
No, I'm not saying that. I'm saying
in
No,
the
I'm not
facts
saying-
of this case, we don't think that is
No,
liable.
I'm-
Technical plea.
No, I'm not saying that. If what my learned friend says, and nothing is in the record.
Lordship, that also I will file through affidavit, Lordship. It will be better for me, Lordship.
In that case, it has to go for a retendering, nothing else. What you can do?
Maybe.
I will file through affidavit, Lordship, through affidavit.
You will have to rely. on
Additional
the
affidavit,
filed by the AFDC.
You go through the record and make proper submission.
Lordship,
Otherwise, it will get prolonged.
Lordship, I will go through that. Yes, Lordship. Any date.
Or what, within 1 week, you can,
No, any date, Lordship.
within 1 week, you can file affidavit.
Yes, Lordship. Within 1 week, I can file affidavit.
Okay, file affidavit. then.
Along with the, I will give a proper submission also in that case, Lordship. But
That I cannot
submission,
vouch
is a-
for.
I find difficult, I scared to giving submission, Lordship. Record says something. I.
Is it a scam or what?
Lordship. Just something,
Inamuddin.
something is there, Lordship, in this case.
State Council is there. Ribokolial, MCTM. We hit you. 1, 4, 3, 4, 5, 6. P. Sharma. Agorkini repeat kori dibo. BD Das. And Senior Counsel is led by AD Chaudhary, Lion Counsel for a petition or present. Mr. Sharma, Lion Standing Counsel AFDC has submitted that he is not yet ready. He has submitted that though he has received the relevant records, he is not yet ready to make submission as regards the materials contained therein. So stop. He has sought he has prayed for a week's time either to file an additional affidavit on behalf of the respondent AFDC. So he has further submitted that he will go to the records and make submissions on the basis of the materials available therein on the next date of listing.
Let them file an additional affidavit. We should know what he is trying to say. Last 3 occasions, my lord, we did not.
Yes, we will file additional affidavit, we will file lordship.
How much time? 1 week.
1 week date.
Okay, list the case next Thursday.
Date
It was
maybe.
Tuesday, no, John. Tuesday, Thursday, next Thursday. Asani give us the decision.
Where, my lord, in the meantime.
Wednesday lordship.
Thursday.
We should have.
Given date, 21. huh? Given okay.
There's one 1/6 coming.
21.
1/6 coming.
Item number 4.
If you don't file, no, come with the record.
Let them file.
I will file affidavit lordship.
So that we understand what is what.
Yeah, in record lordship, if I say something, then also I may be in trouble lordship.
No. Yes. Fishery,
Yes, my lord, in that I had relied upon a division bench judgment.
yes.
Which was
You have,
the Dhornath Brahmaputra judgment,
huh?
Dhornath Brahmaputra division bench judgment,
Horna Brahmaputra.
writ appeal 186 of 23. In that, my lord had asked asked you as to whether the government is relying upon
I to the actually, video. Keep it on the yes. Yes. Division means W.
writ appeal 186 of 23.
Yes.
In that, my lord had asked as to whether the government is relying upon the gazette notification. Is there any affidavit filed? I have come across one affidavit filed in another connected, in a separate case. In WPC 4450. This case was part of the writ appeal case, my lord. In this case, my lord, in paragraph 5, page 3, the government filed by the joint secretary, my lord. The government has, in its affidavit, has stated that at para 5, my lord, as regards to the statement made in para 3 of the writ petition, the deponent begs to state that in the NIT it is so. The terms and conditions were laid down as per the provisions of the Fishery Rules 1953. A specific condition laid down in Rule 12, which applies to settlement of 60% government fishery, as well as executive instructions issued from time to time for submission of documents to ascertain the authenticity and validity of the bids. It is being government circular dated 18/1/2018. So they are relying upon it, madam, while issuing tender. This is a affidavit filed by the Joint Secretary Fishery Department in 4.
Now, if you rely upon that, then your bid becomes ineligible.
I will also go, they will also go.
Now, in such situation, as an ineligible bidder, whether you can make net selling, because the bid value offered by the beneficiary was higher. So public interest is not going to suffer.
But even then, my lord, they have not followed with the bid conditions, my lord. The bid conditions were not followed.
We insist on this.
And the bid conditions were not followed, my lord, and the government cannot have a blind eye as regards the violation of the bid conditions, my lord.
Now, when, right, but when public interest is not going to suffer, if you are dismiss your petition.
But there's a judgment now of the division bench, which is still.
But there is a judgment of Supreme Court also.
No, there is
Recent judgment, very recent, rendered by Justice, Honorable Justice, Honorable rendered by Chief Bench decision, Chief Justice, headed by Chief Justice. that for an ineligible bidder, why the court is going to seek for judicial review at the instance of an ineligible bidder, Tata Power, hardly 10 days back, when public interest is not going to suffer because you are lower bidder. He is higher.
That is, his
it not?
bid is apparently higher.
Apparently, you quoted what?
I quoted my lord. $78 lakhs and he quoted my lord 91 lakhs
So 13 lakhs apparently higher.
for 7 years.
Which part of the observation now?
Observation, my lord. In my
Division bench, division.
division bench, in this is SCC online, this is 71. I
No, no,
think it's
division 186.
186.
Which part was dealt with that day?
In the instant case, it starts from in the
Paragraph?
instant case. In mine it is 71, this is SCC online. It starts from in the instant, just before the end, my lord, 3 paragraph before the end. In the instant case, I think 72 or 73.
Yes, yes.
In the
Please.
instant case, my lord, that it starts from there, my lord.
The dealers not be applicable. What does it indicate? Tell me.
This
Ah,
paragraph,
under the aforesaid principle, please.
what
please.
would be impermissible is that if the authorities are not following the provisions of the notification, it would not be open for the tenderers to seek for enforcement of the provision, but the reverse would not be applicable.
I have not understood this part.
Yeah.
I have not understood this part. Please tell me.
That if the tendering authorities are following the provisions, the same warrants an interference on the principles of provisions of notification being not enforceable.
Ah.
So my submission is that, though it is saying that it is held by the division bench, that if they are not following, then the tenderers cannot come and enforce. But if the government settling authorities are of the view that it has to be followed, then SM needs to be followed, man.
So in your case, it is not followed.
In our case, in their affidavit, they have not mentioned anything about the gazette notification.
So you cannot enforce. As per the
But-
division bench judgment,
But my lord, there, because this gazette notification has come after the, has come prior to the tender notice. my lord.
whatever, the division
And gazette
notification
notification,
says,
there are judgment.
it the notification says that if it has been decided that the following clauses are to be included in the NIT
Yes, my lord.
for settlement of 60% category fishery, right? So these are not included in your NIT.
It was there, my lord.
Where?
All these clauses are there, my lord. If my lord may kindly peruse my NIT. Page 37. And compare it with page 51. Fishing experience certificate is COG. Or the vernacular one, it will be better, my lord. 45 মাছ ধরা অভিজ্ঞতা প্রমাণপত্র ক that is number 3 in page 51.
These were since time immemorial. Question is that this has to be submitted from this authority, this
District
authority.
fishery-
Those are not there.
District Fishery Development Authority.
These are, Mr. Count, you are doing fishery cases for 10 years.
I've been doing.
So these clauses are always there since last 10 years.
But
It has not changed.
But-
It has not changed.
but to streamline
100% is always there.
to streamline
But
the
the-
process.
Authorities. Right, this notification is for streamlining,
Yes, sir.
but that has to be incorporated specifically. That is what the notification says. That is not there. So division main judgment.
Even the IPO and the all these are there.
See the notification, please. 100% actual fishermen, submission of 100% actual fishermen certificate of fishing cooperative society, SHGs, NGOs, issued bold in bold,
Yes.
issued by the ARCs.
Yes.
That is not mentioned here. Yes.
Is mentioned that অনুসূচিত জাতি মহিমাল সম্প্ৰদায়ৰ লোক হোৱা প্ৰমাণপত্ৰ আৰু ভিত্তিত মাছমৰীয়া লোকে মীন পালক হোৱা প্ৰমাণপত্ৰ।
দিব লাগিব, but from whom? দিব লাগিব, that is not there. So this notification was not part of the standard notification.
But
Now-
but there are judgments which says that it has to be taken.
Settlement order also did not indicate that they have referred to this. Settlement order 49.
It doesn't indicate.
In the meantime, all these decisions have come. Whether any judgment says specifically that this notification will govern all cases of fisheries,
Yes, sir.
then that would have been very easier for me.
But
But this division bench says, see the division bench paragraph 71 in your order.
Yes, sir. But the previous paragraphs, my lord,
Whatever, that is a finding, Mr.
yes. But
Clear finding.
But this is in respect to that case, it says, my lord, in the instant case, the settling authority in the order dated so and so have followed the provisions of notification dated 18/1/18.
Followed
Follow.
specifically,
And now,
specifically observed, but the
and
observation.
now they cannot pick and choose because they one.
Mr. Count, that will not do, that judgment is. See, under the aforesaid principle, what would be impermissible is that
Yeah.
if the authorities are not following the provisions of the notification. And from the settlement order itself, Mr. Count, it is clear that they are not following the provisions of the notification. They have made settlement in favor of the beneficiary on the basis of certificates they have given.
So then, my lord,
It is clear they are not following.
one thing can be
Then-
done, my lord.
Then it would not be open for the tenderers to seek for an enforcement of the provisions, meaning thereby you. Mr. Count cannot enforce. This is the division bench observation.
It is for the tendering authority to decide, my lord. And now
See,
they cannot pick and choose.
This
just
has
one.
left you at nothing. This division, I thought that this will come in your aid, but this has left you at nothing. Am I not clear? See the observation. This is difficult now.
Let them, otherwise let them file an affidavit whether they're relying upon the gazette notification or not, my lord. Because in one case, they cannot say that we will adopt, in other case, they cannot say we will not adopt, my lord. Because ultimately it is public.
All this has created things very difficult. Coming
Yes, sir.
for a single court judge.
And this NIT was issued after the gazette notification came into effect. my lord. NIT was 9/2/2021.
Because two things have created difficulty for me. Because that says, notification says, these are to be incorporated in the tender notice.
Yes, my lord.
But deputy commissioners are not incorporating.
So that is why it has to be
Right,
laid down, my
or
lord.
at least if any mention is made in a tender notice that terms and conditions of the gazette notification will govern the matter of settlement of this.
My lord may lay down the law, my lord, that if from future onwards.
Something has to be done because otherwise it is very difficult. If that is, those are incorporated in a tender notice, litigations will be reduced. And Mr. Chetia does not want it.
And
That is why they are not incorporating this gazette notification in the tender notice.
and apparently, my lord,
Because they want litigation to flourish. So that they can have that free hands. One minute. Where are there, which you have challenged?
I have challenged the settlement order page 49.
No, the
The
documents,
documents I have challenged, my lord, is
just let me have a glance. What are those doubtful documents?
at para 15 I mentioned, my lord.
No, come to the document.
Documents, my lord, documents, my lord. Page 60.
1 minute. Senior application. Then
Then this is the fisherman experience certificate. Then 61 is the Bakijai clearance certificate.
what is wrong with it?
It is in the name of the individual, my lord. And
Some overlapping is there, overlapping.
60, my lord, the wrong is that it is to be issued by the fishery development officer. And the circle officer has given the certificate.
I think page 64 is doubtful.
Then, my lord,
Page 64 is doubtful.
Gaon Panchayat has no role to play.
Which one is Gaon
Page
Panchayat?
62. Whether there is any pending tax, they have no rules on it.
How many members they have?
They have not specified, they mentioned 10 members, but at page 64, it is mentioned that it mentions, my lord, that also the members of society are scheduled caste members, my lord. Only so and so are members. And in the affidavit, they are silent about that, my lord. Then, my lord, registration certificate, there is no issue. Audited balance sheet, they have given for 2 years, my lord.
And requirement?
Audited balance sheet, requirement 3 years, 3 years.
Where
And
is
the
that?
audited balance sheet has to be given by the
Where is that in the tender notice vernacular?
audited balance sheet, my lord, vernacular.
That requirement is 3 years.
সমবায় সমিতিৰ বছৰেকীয়া বেলেন্স শীট আৰু লাভ লোকচানৰ হিচাপৰ কপি. That is from the Gazette, my lord.
Oh, Gazette, all are Gazette. That is also not there. They have submitted for how many years?
2 years.
2 years. That is not the requirement of the tender notice.
Then, my lord,
And so far, what is this? Anuhuchito? Page 64 is what?
Page 64, my lord, is the 100% caste certificate, my lord.
Huh?
It says my caste certificate, my lord. Majority are scheduled caste. Not all, my lord. And as per the fishery,
No,
rules, my lord,
no. Language is not that. Falls under scheduled caste area where majority, full stop.
yes, my lord.
Then also the members of the society, including president and secretary, are scheduled caste person. Effectively, all are scheduled caste.
Yes.
But question is that what kind of authority it has?
And this
It is a voluntary organization.
voluntary.
Yes. Are you admitting this kind of document?
Yes, my lord.
Dedicated to the 100% master original Praman Patra.
And
This Praman Patra, who will give?
as per the,
Don't go to the notification.
yes, my lord.
Otherwise, who is the authorized person?
Yes, my lord. My lord, Zila Onusito Zati Porishad, my lord, they were authorized by the my lord government to issue this kind of certificate, my lord. Because my lord, all caste certificate, my lord, they issued by the scheduled caste, my lord, position, my lord. All scheduled caste certificate.
Whether this organization issues?
Yes, ma'am. Well, this organization issued, my lord, it should be thereafter countersigned by the my lord, deputy commissioner, my lord. Thereafter.
That is individual.
Individual. In respect of,
Individual caste certificate.
yes, ma'am.
Right.
Yeah.
If it is ST,
Yes.
then other litigation says that rule 3 of that tribal sangha,
Yes.
all Assam tribal sangha, countersigned by deputy commissioner of SDO. So far, I think subdivisional schedule
There's
caste
a
board, something like
There
that.
is a fourth.
Mr. Gogoi, please tell me. It is, I think, a subdivisional schedule caste board, something like that.
Development.
Not this Guwahati Jila Anusachita Jati Parishad. I don't think this is a voluntary organization. Yes, Mr. Bokolial, who issues SC certificate?
SC certificate issued by Lordship Scheduled Caste Development Authority Limited, countersigned by the SDO, this Deputy Commissioner.
This authority, this organization, see the language, Anusachita Jati Hewat Utporgito.
They are not the authority.
Or Rajnaitik, Samajik and Seshasevi.
Yes.
They
They are
cannot
not
be.
the authority, Lordship. But they are the registered society, otherwise they are.
Registered society is
Service of-
defined it.
Lordship,
Recognized by the, in the certificate, my lord, it is
No, no,
recognized by the
Mr.
government of.
Yeah,
Yes.
one has to be a certificate from a competent authority.
Yes.
And normally, we see that Assistant Register of Cooperative Societies who issues that 100% of the fishery cooperative society belongs to scheduled caste.
Scheduled caste. Yes, I am calling.
Yes, Mr. Das, why you are silent? How this? How do you justify this?
All the members of the society.
Maybe,
Scheduled caste.
maybe
Yes.
it requires Praman Patra. Praman Patra does not mean from Mr. X.
Yes.
Praman Patra means a Praman Patra from a competent authority. Your certificate does not indicate.
Certificate are issued by the deputy commissioner, some are issued by the sub-divisional officer, SC development.
But
Board.
your page 64 does not say so.
In affidavit in opposition, my lord.
I don't know, it is, but
All the
Petition,
certi-
petition.
All the members of the,
petition, read petition, page 64. And it is not your case that you have submitted something else. Is there anything, Mr. count that they have
And-
submitted something.
No, this is, I got this document from RTI, my lord. They have submitted this document.
Mr. Sethi, you have the records.
Yes, ma'am.
What document they have submitted?
My lord, documents which were annexed with the writ petition, my lord, they all documents are similar to the.
Any additional document
No, my lord.
regarding this 100%?
100%.
Say 100% members of the society.
Hmm.
Uh, hmm. অনুসূচিত জাতি লোক হওয়ার প্রমাণপত্র।
Yes, my lord.
Any other document?
There is no such other documents, my lord.
The members of the society are all civil caste and their certificate are annexed in the affidavit of position.
That is-
Members of the.
That is not in the record, my lord. They have filed in the affidavit.
Not in the record, later on in the affidavit. How many members?
10 members.
10. So, Mr. Khan, without going into this notification and the controversy, we have to decide it.
And the judgments which I have relied upon.
Which judgment?
I had given.
You have given so many judgments.
Oh, yes, my lord.
Which one? Which one?
There's a list, my lord.
Least I have seen. Which one specific? We cannot go on relying on every judgment.
On the facts, my lord. On the facts, my lord.
Because notification says it has to be included. Division bench says para 71. If they are not relying on, it seems that they are not relying on.
But there's one judgment which my lord can rely upon, that the Titiriaguri, my lord, judgment, where they had said, my lord, read WPC 3215 of 2021, wherein, my lord, the government council.
Government council submission is not binding. Unless it is advocate general.
Para 25, my lord.
Now, in the face of the division bench judgment, we cannot go on this thing.
Yes, my lord.
Right. Division bench. Council submission is not above the division bench judgment.
Yes, my lord, that's true.
So on the facts of the case only.
Yes, my lord.
That is what, just go to Tata. So your pen is doubtful. What is the observation made? Zia
And that
Koti,
was not in the name of the society.
accept. And this can be a ground. All others are
I have complied with all the other conditions.
the other two bidders.
Other two bidders, my lord. Yes. Page 14, my lord. Are the
Page
one
49, page 49.
39 lakhs, 14, 1/4.
34 number, Sathi Tala is also defective. Then, so you and other two bidders were defective.
Yes, my lord.
Now you want to say that the respondent society is also defective.
Yes, man. That is my son.
Yes, my lord. My lord, he himself is defective, my lord. Now he is
Then
selling.
he can go for
Right.
judicial tender.
Right, but you have acted upon some documents
Yes.
of an organization which is simply an NGO.
Yes, my lord. That is correct, my lord. If my lord, the gazette notification, if my lord, that notification have been, my lord, followed.
That
my
is
lord,
what I call.
That dispute has not arisen, my lord.
That is what the thing we have deliberated upon.
Yes, my lord.
Nobody is saying that without the tender condition specifically incorporated, this gazette notification will come into force
Yes.
directly. That is not saying. No other court is saying. Right.
Yes.
So on the basis of the facts available on record now, we have to decide.
My lord, because the tender.
Now the testing is that he is out.
Yes.
But why you have deviated to act upon a document which has been given by an organization who is not competent to issue such a certificate?
That is true, my lord, but even my lord, the tender condition, my lord, that is also not specifically mentioned that, my lord, such kind of which kind of documents should be, my lord. admitted.
So, if it is not specified, then it should be a competent authority.
Yes, my lord.
Cannot be an incompetent authority like some NGO, some club. If you can show me that this particular document is by page 64 document is by an competent authority, then things will remain or not. Okay, what other parties dictated?
Yes, my lord.
Thursday will dictate, Thursday will dictate. Thursday will dictate.
My lord, 2 points may be decided.
2 points, what more?
Consider.
Please come this side.
Petitioner has not challenged the tender notice, my lord. Moreover, the petitioner has been defected, he has no locus standi to challenge the settlement order. So your lordship can consider.
Okay. Tender notice not challenged,
Yes.
but tender or settlement order has been challenged or not?
Settlement order challenge, but
Challenge. Now, sir, there are two things.
Yes.
One principle is that if the petitioner himself is an ineligible bidder, he cannot mount a challenge in favor of award of a contract in favor of another bidder, unless it is public interest is not, unless public interest is involved. Second principle is that the government or state are bound by the norms and standards they have professed. So, in his case, they have treated him as invalid because PAN card was not in the name of the society. But he has,
My lord, but
he has pointed out 3 defects, at least about your status as a society comprising of 100% scheduled caste. Right? And the third proposition is that if public interest is not involved, why should court interfere? All the 3 possibilities are there. See that not because public interest is there, mister, your bid is lower.
Caste certificate is issued by the same authority in favor of petitioner and also respondent. my lord.
Is it so?
Yes, madam. The record is there. my lord.
That is not a ground for rejection, my lord.
We are not going to
That
do.
is President has to be set, my lord. Because it has to be set by them, my lord.
We'll not go into all this then, public interest that whether at the instance of a lower bidder will go to
But
interfere with
One judgment
with
there
a with
was-
a award of a contract.
One that judgment I had given, my lord, that is a single bench judgment of this court, When an eligible bidder had challenged the tender process, my lord.
Can challenge. Can challenge. Go through this recent 3 judge decision,
Yes.
Tata Power.
Yes, my lord.
Ineligible bidder, he can challenge. Ramana Dayaram Sethi says as far back as 1978. But question is now whether court will make just for making a legal point, court will interfere or not. If public interest is going to be suffered, court will interfere. If public interest is not going to be suffered, court should keep its hands away. More particularly when, in your case, you are a lower bidder.
Even
So unless you can, this is my tentative view, which I am going to do.
even records, even there is a political recommendation also in his.
We are not going to that political.
Their judgment lordship has indicated Tata Motors and Vihan Mumbai. Lord.
Tata Motors.
It was authored by Mr. Justice Pabriwala lordship.
Ah. 3 judges, I think.
3 judges bench judgment, paragraph 49 lordship's view is that view. Paragraph 49.
So at the instance of a lower bidder, that is the, we are not going into that dispute. Because division bench has not supported your case because we have recorded all your submission on the basis of that notification.
Yes, sir.
Day after tomorrow we'll dictate. This 186 was the only writ appeal where this government notification was involved.
Another it
There
was
is
also
pending,
pending, my lord.
Another,
it appeal was also pending.
that is also
It
pending, my lord. That is writ appeal 88.
আজ এটা দিল নাকি 19 একটু জ্বর যদি আছে 19 কিন্তু দিল এই ওকে 19 then 14 some other case over there 19 Tuesday Let's count. MCT. Yes, does. Release the case again on 19. Indian admission. We have recorded more or less.
Yes, sir.
এইটা করে দিব তবে কোনো এটা থেকে দিব এই নোটস দিব চলে গেল চলে গেল একটু 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 একটু
Item number 6 for hearings.
Yes, Mr. Bogoti, he was sitting, and I have seen you sitting.
Yeah.
What is the subject?
Is concerning my lord, the roadside stalls. And that was given position to different people. It is not by way of auction. Here the auction meter doesn't come, like all the cases I heard. Only is governed by municipality, Assam municipality Act of 1956. And so the anomalies galore. And here, my lord, I start by case. The chairman of the Dumduma Town Committee leased out a plot of land and Nehru Road situated wider area in favor of the private husband of 5. Private husband of 5, whether he's here or actually he's not so important, my lord. I understand. By violating section 43 and 47 of the Assam Municipal Act, 56, without convening any board meeting for adopting resolution under section 43 of the said act. So before the court, I submitted one day, then let the record be called for. Accordingly, it came. And what record has been called for, my lord? I'll show you. Accordingly, the record came.
Mr. Chetia, you represent board,
No, my lord, town committee.
town committee.
No, my lord. I was directed to call for a record, my lord, bring the records, my lord. I have received the records, my lord.
And
You have received a record.
Yes, ma'am.
We work on.
You are with, the records are with you.
Yes, my lord. I am asked to office to send the records, ma'am.
Yes.
So there's an order, my lord, in the record. We were going to submit that he has received the records and this already petition be listed for final hearing on, sorry, 3822.
Okay, get the records Thursday.
No, we have changed the record.
No, he will get the record Thursday. It is available in the office.
Yes, yes.
It is available in the office.
They have also inspected the record, my lord, earlier occasion, my
No, no,
lord.
let it
Yes,
come
yes,
before the
ma'am.
court.
They were allowed to.
I will show you
inspect
before the court. What is the
Okay.
record?
Thursday,
Yes, ma'am.
day after tomorrow.
Yes, yes.
Okay, day after tomorrow, he'll get the records.
Yes.
Get the records.
Yes.
Yes,
Day after tomorrow, Thursday.
it should be at the top of the list, my lord.
S.K. Borkatuki petitioner. M. Chetia, Learned Junior Government Advocate, Assam for response number 124. And as count.
For 5.
5. Are present. First of Mr. Chetia, Learned Junior Government Advocate, Assam has submitted that he will produce the relevant records on Thursday.
Yes.
Yeah, Thursday. List the case on Thursday. Admission or hearing?
Hearing.
At the top.
Thursday.
At least in a convenient manner, because otherwise it doesn't come in time. Last time also.
We'll try.
If
Try to
possible,
accommodate.
if possible.
Try to accommodate.